So let me find out.
Okay, now we
I
are.
do
We're
have a square at the top of my screen that says that it's live on custom live streaming service.
That just went on.
Okay. So let me find out. So we're now live. Live. Okay. That says that it's live on custom live streaming service.
That just went on.
Okay. And somebody does have their microphone not muted, and I'm hearing an echo. So go ahead and everybody mute their microphone, please. Kaylee, could you mute your microphone as well?
Your Honor, I'm not connected to the audio, so the feedback should not be coming from my device.
Okay, so there is a secondary Kaylee Langan. Do you have your phone also on? There we go. Thank you. So now that we are live, I will ask the gallery members, including the teachers and attorney coaches, family members, and friends, to please raise your right hands. And I know that I cannot see you, but that's the world we live in. And I'd like you to also swear an oath. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? And I'm assuming everybody's saying yes. Now, the next is the scoring panelists. If I could have you raise your right hands. Thank you. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible and in accordance with the facts and procedures and rules of the mock trial competition?
I will.
Yes, Your Honor.
Thank you. So now let's go ahead and get started with the competition. I would like first to have you introduce yourselves, but hold on one second before you get started, because I need to get my trial rosters up. So Team India, first of all, are you defense or prosecution?
Or prosecution, Your Honor.
Prosecution. Okay, so to the prosecution, would you please start your introductions?
Yes, Your Honor. Your Honor, members of the jury, opposing counsel, good afternoon. My name is Anna Debler, and today I will be conducting the direct examination of Detective Jordan Markowitz, the cross-examination of Taylor Perkins, and providing the opening statement.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Kaylee Langan, and today I will be providing the direct examination of Alex Cifuentes and the cross-examination of Avery Becker.
Thank you, Ms. Langan.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Anjali Mishra, and I will be providing the direct examination of Kyle Cusack, the cross-examination of Blake Van Owen, and I will be also presenting the closing arguments for the prosecution. Your Honor, at this time, we ask that our witnesses be allowed to introduce themselves.
Thank you, Ms. Mishra. Go ahead.
Good evening, Your Honor, members of the jury. My name is Hannah Moskowitz, and I am Jordan Markowitz.
Thank you.
Good evening, Your Honor, members of the jury and opposing counsel. My name is Maggie Holland, and I am Alex Cifuentes.
Thank you.
Good evening, Your Honor, and members of the jury. My name is Raina Hilden, and I am Kyle Cusack.
Thank you. Thank you for your introductions. Now for the defense, Could you please make introductions?
Good evening, Your Honor and members of the jury. My name is Grace Murphy, and my co-counsel and I represent the defendant, Avery Becker, in today's case. Permission for my co-counsel to introduce themselves?
Absolutely. Go ahead.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Lola Fakes.
Thank you,
Good
Ms.
afternoon,
Hayden.
Your Honor. Good afternoon, Your Honor. My name is Tess Hayden.
Thank you, Ms. Hayden.
Permission for our witnesses to introduce themselves?
Absolutely. Go ahead.
Good afternoon. My name is Lily Humber, and I am Professor Blake Van Ellen.
Good afternoon. My name is Saffron Bennett Spurlock, and I'm Avery Becker.
Thank you.
Good evening. My name is Alexandra May, and I am Taylor Perkins.
Thank you. Welcome everybody to this competition. We are going to go ahead and get started. Thank you for your introductions. Is the prosecution ready to start their case?
Your Honor, just before that, the prosecution has a few pretrial matters to address.
Yes, certainly.
Your Honor, the prosecution would ask that any time left from the prosecution's closing argument would be reserved for a rebuttal.
You can certainly do that.
Your Honor, the prosecution also asks that all of the witnesses except the defendant would be constructively sequestered.
We will address that at the time of the trial, once the trial is started.
Yes, Your Honor. Your Honor, the prosecution would also ask that we would have permission for trial technicians to display exhibits on the screen for the purpose of entering them into evidence, or if they've already been entered into evidence for expedience sake.
Certainly, that'll be taken care of.
Yes, Your Honor. Your Honor, as exhibits are initially displayed on the screen, the prosecution would ask that it be recognized that this is just to display the exhibit to the witnesses and opposing counsel, not to the jury until the exhibit has been published.
Certainly.
The prosecution would ask that exhibits, once they have been entered, would be constructively published to the jury and available to be annotated, and they'll just remain on the screen.
No problem.
And Your Honor, we just ask that these courtesies are extended to opposing counsel.
Certainly.
Yes, no further matters.
Thank you. Counsel for the defense, do you have any preliminary matters that you wish to address at this time?
Yes, Your Honor. We just have one matter at this time. We ask that the stipulated facts agreed to before trial today be constructively read into the record.
They will be constructively read into the record, not actually read into the record. Yes.
Thank you.
Any other matters?
No, Your Honor.
Thank you, counsel. Ms. Dobler, are you ready to proceed?
Yes, Your Honor.
Okay. You had a pretrial matter that you wanted to address with regard to the witnesses.
Yes,
Do
Your
you
Honor.
want to address that now?
Yes, Your Honor.
Go ahead.
Your Honor, the prosecution would ask that all witnesses except the defendant would be constructively sequestered.
Okay. Any objection to that from the defense?
No, Your Honor.
Thank you. The witnesses will be so sequestered. Ms. Dobler, you may proceed.
Yes, Your Honor. May it please the court. Your Honor, members of the jury, my name is Anna Debler, and today, along with my co-counsel, Anjali Mishra and Kaylee Lingan, today I represent the people of the state of Colorado to bring forth the charges of murder in the first degree and burglary in the second degree against the defendant, Avery Becker, and prove beyond a reasonable doubt that the defendant is guilty in this case. Members of the jury, this is a case of the defendant's revenge gone wrong. For the past couple of years, the head coach of the Colorado High School mock trial team and litigator, Mackenzie Brackman, volunteered his time with students. However, you will learn from the evidence provided today that one student in particular had a contentious relationship with the coach. Avery Becker, a senior on the team and the defendant in today's case, is very passionate about mock trial and naturally skilled. The defendant argued frequently with Coach Mackenzie Brackman about his coaching style. The defendant arrived at practices and trials unprepared, and Coach Brackman disapproved of this. Because of this behavior, Coach Brackman even demoted the defendant to the B team, angering the defendant further. You will learn from testimony today that this relationship took a turn for the worst when the defendant vandalized Coach Brackman's car in a heated argument after the regional mock trial competition. The coach then kicked the defendant off the team. You'll hear today that the defendant pleaded with her teammates, including Alex Cifuentes, for help to get back on the mock trial team. With no success, the evidence will show that the defendant sought revenge on the coach by breaking into the coach's house. However, the evidence will show that this revenge went wrong. On Friday, March 6th, 2020, Coach Brackman was found dead just inside the doorway of his own home. The police concluded that the defendant, Avery Becker, killed the coach. Today, the prosecution will call 3 witnesses to the stand who will provide testimony and meet the burden of proof in this case. The prosecution's first expert witness, homicide detective Jordan Markowitz, will take the stand. You will hear Detective Markowitz has first-hand knowledge of the crime scene. You'll learn that the detective obtained forensic evidence, ring videos, cell tower records, and phone records, all of which tied the defendant to Coach Brackman's house at the time of the murder. Then Alex Cifuentes will take the stand. You will hear that Cifuentes, a senior at Colorado High School, was a member of the mock trial team, observed the tension between the defendant and Coach Brackman, and she will provide screenshots of a conversation in which the defendant showed intent to trash the coach's house. However, that revenge of burglary and vandalism went wrong, and instead ended with the death of Coach Brackman. Then the prosecution's third expert witness, investigator Kyle Kuzak, will provide testimony. You will learn that the investigator also has first-hand knowledge of the crime scene, and she will confirm Markowitz's findings through methodically collected details that describe a struggle as the defendant entered the mock trial coach's home, was surprised that the coach was home, and stabbed the coach. And jury members, be wary of the defense's witnesses. Listen closely to their testimony and look out for any bias they may include. The evidence provided today will detail that none of the defense's witnesses thoroughly investigated the scene of the murder firsthand, and none of the defense's witnesses can provide a solid alibi for the defendant at the time of the murder. At the end of today's trial, my co-counsel, Anjali Mishra, will give the prosecution's closing argument. She will remind you of the important details of the trial that will prove the defendant's intent and meet the prosecution's burden of proof. She will point to this being a case of the defendant's revenge gone wrong that resulted in the death of Coach Mackenzie Brackman. Members of the jury, we ask that you return a verdict of guilty. Thank you.
Thank you, Ms. Dobler. Are you ready to put on your first witness?
Your Honor, may the defense provide an opening statement?
Oh, I apologize. I don't know what I'm thinking. Too tired. Go ahead, counsel.
Thank you, Your Honor. May I proceed?
Yes, you may.
No phones, no files, no felony. Your Honor, members of the jury, my name is Lola Fakes, and my co-counsel and I are here today to represent Avery Becker. Ms. Becker stands here today falsely accused of second-degree burglary of a dwelling and murder in the first degree. The prosecution accused Avery Becker of the murder of Mackenzie Brackman before their investigation even began. They investigated no other leads or suspects, and the incomplete evidence they will present today will clearly reflect that. The prosecution's case is, simply put, unfinished. The prosecution will call 3 witnesses to the stand. They will call Alex Cifuentes. Alex, the prosecution's only character witness, is a mock trial teammate, jealous of Avery's recognition in mock trial competitions. You'll hear that Alex was the last person to see and use Avery's phone on March 5th, the day before the murder, the same night that Avery's phone was lost. Alex claims to have had a text conversation with Avery about her plan to go to Mr. Brackman's house. Now, you will also hear from Detective Jordan Markowitz, who will try to explain why she accepted screenshots of this purported text exchange directly from Alex, with no attempts to verify their authenticity. None. You'll hear that the cell tower data collected by Detective Markowitz from Avery's phone the day of the murder cannot tell us where Avery's phone was that day, as phones do not always connect to the tower closest to them. Professor Van Owen, the crime scene investigator who will testify later today, will explain that cell phones commonly connect to towers up to 7 miles away from the phone's location, meaning a cell phone in downtown Denver could connect to a cell tower in Stapleton. While the data may give us a picture of the phone's location during Mr. Brackman's murder, it can tell us nothing of the location of Avery that day. You'll hear that Detective Markowitz has failed to locate Avery's phone. Detective Markowitz has failed to obtain Alex's phone to authenticate the purported text exchange. The detective also failed to obtain the one phone that could confirm or deny their lead suspect's alibi, Taylor Perkins' phone, as Taylor was with Avery on the day of the murder. Where is Avery's phone? Where is Alex's phone? And where is Taylor's phone? All untouched by the police and not in court today. Kyle Cusack will also be called to the stand. Cusack, a civilian worker on the police force, will try to reconstruct the crime scene for the court, but will fail to do so properly or convincingly. Cusack visited the scene after it was processed by Detective Markowitz, using only the evidence that she collected, following her leads. Additionally, the police allowed important picture evidence to be corrupted, making it unavailable to the court today. Members of the jury, this is just another example of the unacceptable incompetence of the detective work on this case. The defense will bring to the stand crime scene investigator Van Owen. Professor Van Owen will help highlight the failings of the police investigation. The ridiculous reconstruction of the scene, of scuff marks that cannot be dated, of ring notifications that were never checked, and the impossibility of a teenager of Avery's stature to reach the knife wound found on a grown man's shoulder. You will also hear from the defendant herself, Avery Becker. Avery will clearly explain to you that she did not commit this crime, and that she, a teenager with a loose connection to Mr. Brackman, is not the criminal they are looking for. Lastly, you will hear from Taylor Perkins, Avery's alibi, who will fully corroborate the whereabouts of Avery on the day of Mr. Brackman's murder, making it ever more clear that Avery had absolutely nothing to do with this crime. Members of the jury, Mackenzie Brackman was a criminal defense attorney, a job that will naturally provide you with enemies. Yet Detective Markowitz will fail to acknowledge any other suspects in this case. Taylor Perkins will bring your attention to Blair Rollins, a fellow Colorado high school student, whose father was put into jail. And who was his father's defense attorney? Mackenzie Brackman. You will hear that Blair Rollins was not at school on the day of Brackman's murder. You will also hear that Blair Rollins seems to have recently disappeared. You will not hear of any investigation of Blair Rollins by the prosecution. No phones, no files, no felony. The investigation on Mackenzie Brackman's murder is simply put, lazy. The prosecution found only the evidence that supported their claims and ignored to look into any other leads, theories, or pieces of evidence that would contradict their choice of suspect, Avery Becker. I will remind you, members of the jury, the prosecution holds the entire burden of proof in this case. I ask the jury to keep in mind that the prosecution must prove their case beyond a reasonable doubt. It is your job, jury members, to ask yourself through every moment of testimony today if there is any reasonable doubt. I ask that you remember what the prosecution is missing from their case. No phones, no files, no felony, and find my client, Avery Becker, not guilty. Thank you.
Thank you, Ms. Fick. Now is the prosecution ready to start with their first witness. Ms.
Yes,
Dobler?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand.
Thank you. Ms. Markowitz, remember that you are under oath. You may proceed, Ms. Dobler.
Yes, Your Honor. Hello, Detective. Can you please state your name and spell your last name for the record?
Of course, that's Detective Jordan Markowitz, Markowitz.
Now, let's start talking about your employment. Can you please tell the jury a little bit about your employment history?
Of course, I've been working with the Denver Police Department for the past 13 years. However, for the past 7, I've been a homicide detective there.
And do you have any special training in certain fields?
I do. I took a 3-day course at the American Academy of Law Enforcement in cell phone technology and forensic data recovery. In order to complete this certification course, I did have to pass a test.
And do you use this training in the field regularly?
I do. I have obtained and interpreted cell tower data in over 50 cases.
Your Honor, at this time, I move to tender Detective Markowitz as an expert in criminal investigation, cell phone technology, and forensic data recovery under Rule 702 due to her skill, experience, and training.
Any objection to this witness?
No voir dire at this time, Your Honor. I'll address her shortcomings on cross.
Thank you. You may proceed. The witness is accepted as an expert in those fields.
Yes, Your Honor. Now, Detective, let's talk about today's case. What was your role in today's case?
I was called to the scene of the crime at 444 South Flower Street on March 6, 2020 to the home of Mackenzie Brackman.
And what did you conclude about today's case?
Well, I concluded, first and foremost, that the defendant, Avery Becker, was guilty of all charges. Now, I did this with 3 things. The first, Mackenzie Brackman died in a struggle. The second, the defendant had the intent to trash the home of Mackenzie Brackman. And the third, cell tower records placed the defendant, Avery Becker, at the home of Mackenzie Brackman at the time of the murder.
Now, let's look at that first conclusion of a struggle. What did you do upon arriving at the scene of the crime?
Upon arriving at the scene of the crime, I went around the house in an open gate through the back door in which I saw the victim, Mackenzie Brackman, lying face down in a pool of his own blood.
Let the record reflect that the trial technician will be displaying Exhibits 1 through 4 at this time. Detective, turning to Exhibit 1, are you familiar with each of these exhibits?
Yes, I am.
What is Exhibit 1?
Exhibit 1 shows the victim, Mackenzie Brackman, as seen by the front porch of his home.
As we turn to Exhibit 2, what is Exhibit 2?
Exhibit 2 shows the victim's position in relation to the door.
And now turning to Exhibit 3, what is Exhibit 3?
Exhibit 3 is the best image we have of the stab wound that killed the victim, Mackenzie Brackman.
Now turning to Exhibit 4, what is Exhibit 4?
Exhibit 4 best shows the defensive position that the victim was lying in.
And how do you know what all of these exhibits are?
I was there at the crime scene to observe this.
And are these all fair and accurate copies of what you observed on March 6th, 2020?
Yes, they are.
Your Honor, at this time, I move to enter Exhibits 1 through 4 into evidence.
Any objections to Exhibits 1 through 4 being admitted into evidence?
Yes, Your Honor. If the prosecution wishes to enter one of these images into evidence, I have no problem with it, but admitting 4 bloody photographs of this crime scene, I would argue the prejudicial value highly outweighs the probative effect, or the prejudicial effect highly outweighs the probative value.
Any response?
Yes, Your Honor. These images are essential to the case as they do show wound and body positions, which are important to understand the struggle in today's case. The location of the wound on the back of the body is not shown in some pictures, but it is displayed in other pictures. Because there's blood, it's close to, or it's necessary to have pictures that are more zoomed in on the stab wound image. Otherwise, the orientation of the stab wound is hard to see, and that goes to the process of events in today's case.
The Exhibit 1 through 4 will be admitted into evidence and may be published to the jury at this time.
Yes, Your Honor. Detective, using Exhibits 3 and 4, what's the importance of Exhibits 3 and 4 specifically?
Well, if we turn to Exhibit 3, this best shows the victim's stab wound. Now, as you can see, that there is a horizontal knife wound, which indicates that there was a struggle. In addition, if you scroll down to Exhibit 4, you can see that the victim's hands are placed in a defensive position.
Now, from all of this physical evidence, what did you believe to be the progression of events?
I believed that the victim was involved in a struggle in which he was unfortunately left dead.
And now, turning back to Exhibit 1, what else did you notice about the residence?
Well, if you notice in the upper right-hand corner, there is a Ring doorbell.
And did you use these Ring cameras in your investigation?
I did. I illegally accessed several videos that helped me in today's case.
And now let's talk about that second conclusion you reached of intent. Was there any other evidence to point to the defendant as the murderer?
Yes, there was. Once I learned the identity of the victim, Mackenzie Brackman, I found that he was a mock trial coach for Colorado High School. With this lead, I followed the evidence and found one of his students, Alex Cifuentes, who provided me with text messages that stated out explicitly the defendant's
Objection, Your
intent.
Honor.
What is
Best
your
evidence.
objection?
Best evidence. I wish that these texts be entered into evidence if we're going to discuss them.
Counsel?
Your Honor, this witness has been entered as an expert and is just giving their expert opinion on this matter, is not specifically referencing the contents of the evidence.
Any response?
I believe that Detective Markowitz just was about to say these texts said, and I quote. So I believe that she is trying to discuss the contents of these texts.
The witness may continue but may not discuss the contents of the texts at this time without better foundation. Let me put it that way.
Yes, Your Honor. Now, Detective, were these screenshots doctored in any way?
From my expert opinion in cell phone technology, I had no reason to believe that—
Objection, Your Honor. Whether or not these screenshots are doctored is once again discussion of the contents of them.
Counsel, Ms. Dubler?
Your Honor, the witness is simply discussing the screenshots as a whole, not specifically certain words or phrases being used in the exhibit.
The witness may continue to testify. The objection is overruled.
Yes, Your Honor. Now, Detective, I'll ask that again. In your expert opinion, were these screenshots doctored in any way?
No, using my expertise in cell phone technology, I could not find anything that showed that they were doctored images.
And what did you do to investigate the defendant further?
Well, as I was able to obtain an interview, I instead got a warrant to receive cell tower records of the defendant's phone.
And can you please explain to the jury in layman's terms what these cell tower records are?
Of course, I could talk about them for quite a bit, however, I will keep it brief for expediency's sake. These cell data records, or CDRs, are an account of any incoming or outgoing calls that also show the date, the time, and what tower the cell phone was connected to during this transaction.
Let the record reflect that the trial technician will be displaying Exhibit 15 on the screen. Detective, what is Exhibit 15?
This is an exhibit of the CDRs of the defendant's cell phone on March 6, 2020.
And do you often compile data for your cases in this way?
Yes, I do.
Are these fair and accurate copies of the records that you made?
Yes, they are.
Your Honor, at this time, I move to enter Exhibit 15 into evidence.
Any objection to the Exhibit 15 being entered into the record?
I have no problem with 15, Your Honor.
The Exhibit 15 will be admitted to the record and published to the panelists.
Yes, Your Honor. Let's talk about your third conclusion, that regarding the defendant's phone records. So using Exhibit 15, can you please tell the jury what the CDRs indicate about the defendant's phone activity?
Of course. As you see in the upper portion of the image, you can see the defendant's home. Now, if you look at the lower left-hand portion of the image, you can see the victim's home. Now, next to each of these locations that are pivotal in today's case, there is a cell tower. Now, with all this evidence that I've gathered, I determined that from 12:45 to 12:50, the defendant was at her home. However, traveling down Rock Creek Parkway from 1:05 to 1:17 p.m., the defendant was at the victim's home committing the crime.
And in your expert opinion, what happened in today's case?
In my expert opinion, I do believe that Avery Becker went to the home of Mackenzie Brackman on March 6, 2020 with the intent to vandalize his home, only for the revenge to
Objection, Your Honor. Facts not in evidence.
Any response?
Your Honor, this expert witness is simply giving her expert opinion. With her training, she is qualified to make this judgment based on the facts that she does have.
I'll provide a little leeway, but very briefly. I'd like to find out what the facts that she's relying on.
Yes, Your Honor. Detective, what was your expert opinion as to what happened in today's case?
I do believe Avery Becker went to the home of Mackenzie Brackman on March 6, 2020, with the intent to vandalize, only for the revenge to go horribly wrong, and the victim
Objection, Your Honor. Once again, this witness has not laid foundation as to why or how she knows that Avery Becker had an intent of revenge.
That portion will be stricken. Go ahead, counsel.
Detective, what else, in your expert opinion, do you believe happened in this case?
That Avery Becker's revenge went horribly wrong, and that the victim, Mackenzie Brackman, ended up dead as a result.
Thank you. No further questions, Your Honor.
Thank you, Ms. Adler. Any cross-examination of this witness, Ms. Hayden?
Yes, Your Honor.
Proceed.
Detective Markowitz, when a criminal defense lawyer is brutally murdered, your first assumption is often a disgruntled ex-client, isn't that right?
That was my initial belief. However, all evidence led me to Avery Becker eventually.
Just like you said, the only suspect that you investigated in this case was a high school girl that Mr. Brackman coached in mock trial, isn't that right?
Well, I just followed the evidence and it led me to Avery Becker.
Let's discuss the day of the murder. You said that Mr. Brackman armed himself with a knife and that the intruder didn't bring their own knife, isn't that right?
Well, I did not say any such thing. I did believe that there was a struggle and that Mr. Brackman was eventually left dead.
Detective Markowitz, is it your testimony here in court today that Mr. Brackman did not grab a knife to arm himself?
Well, he likely did, yes.
So once again, you believe that Brackman brought the knife, not the intruder?
That is correct.
And you do not know whether the intruder had a knife in their pocket or waistband, do you?
No, I do not know.
So it's possible that there was no struggle over the knife and that the intruder brought the knife themselves, isn't that right?
Well, it's possible, but again, the defensive position and the orientation of the knife wound do indicate a struggle.
Let's talk about that struggle. Some of the only evidence that we have of that struggle were photos of blood spatter, isn't that right?
Yes, that is correct.
But those pictures of blood spatter were lost by your police department, weren't they?
Unfortunately, they were, but as blood splatter only shows the trajectory of the weapons, it wouldn't have showed us the perpetrator of the crime. So,
Detective Markowitz, you said that Mr. Brackman knew that the intruder was coming, didn't you?
Well, as the Ring doorbell does have notifications, that's what I believe, yes.
Right. So Ring doorbells can notify their owners, but you provide no evidence that the Ring notifications for Mr. Brackman's Ring doorbells were turned on, did you?
I don't, but I find it unlikely that a defense attorney would have his off.
So even though you're an expert in cell phone technology and could have easily entered Mr. Brackman's Ring account to find this information out, you chose not to, didn't you?
I didn't find it necessary.
And you said yourself that cell phones don't always connect to the nearest cell tower, didn't you?
Yes, but usually they do.
They will connect to a different tower if they're in a busy area, somewhere like a mall, perhaps.
That is correct, but it was a Friday afternoon, so I find it unlikely there was that many people that it would connect all the way to Brackman's tower.
Let's talk about that cell tower data. If my child technician could pull up Exhibit 15, please. Yeah. Detective Markowitz, do you see Blair Rollins' home on this map?
I do.
And you prepared this exhibit, didn't you?
Yes, I did.
And Blair Rollins' home is in the exact same cell tower range as Avery Becker's, wasn't it?
Yes, it is.
So the phone could have just as easily traveled from Rollins' home to Becker's home.
I guess that is a possibility.
Despite this possibility, you decided to leave Blair Rollins out of your affidavit entirely, didn't you?
Well, yes, as all evidence led to Avery Becker, I decided to focus on the defendant and perpetrator of the crime, Avery Becker.
Let's talk about Avery. You looked into Avery because of some texts sent between Avery and Alex Fuentes, isn't that right?
That was my initial lead, yes.
And these texts are not in evidence today, are they?
No, not right now, they are not.
And the only evidence you have of these texts are screenshots, not actual texts themselves, isn't that right?
Well, unfortunately, I did not get the actual texts themselves. However, evidence from murder cases quickly go cold, and it was of utmost importance that I followed these leads while they were still hot.
But if these texts were fake, you would have no way of knowing, would you?
Well, I do have expertise in cell phone technology, and from everything I could see no doctored images.
Objection, Your Honor. Facts not in evidence. I would ask that the last statement be stricken from the record.
Ms. Dobler, do you have a response?
Your Honor, this has been discussed as the witness is not discussing the contents of the evidence. She's just talking about using her expertise to talk about the quality of the images, that they were not doctored.
The objection is overruled. Proceed with your cross-examination, counsel.
So regardless, whether or not these texts are fake, you don't have any true and definitive proof that they came from Avery Becker, do you?
No, not definitive.
So you didn't think to investigate Taylor Perkins's phone to confirm Avery's alibi, did you?
No, I didn't.
Overall, you have no definitive proof about Avery's phone's location on the 6th, do you?
No, but the combination of all of the evidence does show it was Avery Becker.
And you never looked into any other suspects besides Avery Becker?
Well, I followed the evidence, which led me directly to Avery Becker.
And you cannot prove that Avery Becker ever sent Alex Fuentes a single text?
No, I cannot prove that.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any redirect?
Yes, Your Honor.
Proceed, Ms. Dobler.
Detective, why did you not investigate Blair Rollins as a suspect?
Well, as is my job as a homicide detective, I merely follow the evidence, and all evidence pointed to the defendant, Avery Becker, being the perpetrator of this crime.
Thank you. No further questions, Your Honor.
Thank you, counsel. The witness is excused. Thank you, detective. Ms. Langdon, do you have your next witness?
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
Thank you. Ms. Cifuentes, you are still under oath. You may proceed, Ms. Langdon.
Good afternoon, Ms. Cifuentes. Can you please state your name and spell your last name for the record?
My name is Alex Fuentes, spelled Sifuentes.
Now let's start a little bit with your background. What school are you currently attending?
I am a senior at Colorado High School. Everyone calls it CHS.
And how do you know the victim in this case, Mackenzie Bruckman?
He coached the mock trial team that I was a part of last year.
And how do you know the defendant in this case, Avery Becker?
Avery and I used to be really good friends, and we're both on the mock trial team coached by Mr. Brackman.
Now, you just mentioned mock trial. How did you come to join this team?
It was actually Avery who first introduced me to mock trial and convinced me to try out.
And now, looking a little bit more at the defendant in this case, what is your opinion of the defendant?
Although we were besties, and I'd never say this to her face, but she was never on time or prepared, which was just like so annoying.
And based on your observations, how did the defendant treat the victim in this case, Mackenzie Bruckman?
Mr. Brackman was always pushing Avery to do better because he could see the natural talent in her, but Avery refused and just played the victim instead.
Now, I'd like to move on to an incident in which the defendant and the victim, Mackenzie Bruckman, butted heads. Can you please describe the events leading up to the first incident in which the two butted heads?
Well, after Avery came to practice late again, Mr. Brackman demoted Avery to the B team. And after that, Taylor also stepped down so that Avery could get back on the A team.
And was this the only incident in which the defendant and Mr. Bruckman butted heads?
No, it was not.
Can you please describe the second incident in which the two butted heads?
At the very next practice, Mr. Brackman tried to explain to Avery that there was a big difference between being a good lawyer and being a good performer. He told her that to be a
Objection, Your
success.
Honor. Hearsay?
Any response?
Yes, Your Honor. Under Rule 804.4, this is an exception to hearsay because the declarant is unavailable due to his death.
Ms. Fairfax, do you have any response?
Yes, Your Honor. I believe under 804.4, the fact that the declarant is unavailable, it does not make this, is not an exception for hearsay. It is just the criteria for being unavailable.
The objection is sustained. Proceed, Ms. Langen.
All right, let's move on, Ms. Cifuentes. How did the defendant react after receiving these comments from the victim, Mackenzie Brockman?
Well, from what I saw, Avery stormed off and wrote on Mr. Brackman's Porsche, "Worst Attorney Award" in all caps with a permanent marker.
Now, just to clarify, was this hateful message written in a permanent marker or a removable marker?
It was a permanent marker. There's a big difference, and Avery is not stupid.
And what happened after the defendant vandalized Mr. Brockman's car?
Mr. Brackman kicked Avery off the team permanently.
At this time, I would like to direct your attention to Exhibit 14. Let the record reflect that the trial technician will be presenting Exhibit 14 on the screen. Now, Ms. Cifuentes, do you recognize Exhibit 14?
Yes.
What is Exhibit 14?
It's a screenshot of the string of text messages that Avery Becker sent to me.
And how do you know what Exhibit 14 is?
I was the one who received these messages from Avery on my phone.
Your Honor, at this time, I move to enter Exhibit 14 into evidence.
Any objection to this exhibit?
Yes, Your Honor. The defense objects under Rule 1003, admissibility of duplicates. This document, this screenshot, requires the original in order to prove the authenticity of its content, being the text.
Any response?
Yes, Your Honor. I believe under Rule 1003, it does state that duplicates are admissible in the court of law. And seeing as Ms. Cifuentes is under oath and testifying to the validity of these exhibits, I do believe that they are best evidence and admissible as a duplicate.
Response, Your Honor?
Yes, briefly.
Under Rule 1003, they are duplicates are admissible to the same extent as the original, unless a genuine question is raised about the original's authenticity or circumstances make it unfair to admit. And I believe a question has been raised about the authenticity of its content, and an original is required to even prove the authenticity.
I'm going to admit Exhibit 14 into the record. So you may proceed. The
Yes, Your
exhibit may be published to the panelists.
Yes, Your Honor. Now, Ms. Cifuentes, just to clarify, who are these text messages from?
These text messages were sent to me from Avery.
And now, would you please read along with me as I start from the fourth text message from the defendant? The defendant texts, "Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house." Then you, Ms. Cifuentes, respond, "What are you going to do to his house?" The defendant then responded, "I'm going to wait until he's at work, then break in and trash it." Did I read that correctly?
Yes, you did.
Now, moving on to the day after the murder of Mackenzie Brockman, or March 7th. What happened on March 7th, 2020?
Well, after the cold-blooded murder of our beloved coach, Mr. Brackman, I got a call from the police detective.
And what did the detective ask of you?
Well, of course I didn't want to rat out Avery because I could never lie in a murder investigation. I told the detective about the text messages I received from Avery.
Now, you told the detective about these text messages, but did you ever show the detective the original text messages?
Unfortunately, no. On the day I went down to the station, I forgot my phone, but I offered to send it, and the detective said the screenshot was fine after I had sent the screenshot.
Now, Ms. Cifuentes, are you aware that you were being accused of fabricating these text messages between yourself and the defendant?
Yes, how outrageous. I may be the queen of mock trial, but I am no drama queen. I just don't have the time to do something like that ridiculous accusation.
And Ms. Cifuentes, are you also aware that you are being accused of stealing the defendant's phone?
Yes, this is just as outlandish as the last. I really liked Mr. Brackman as a person and as a coach, so I would never do anything to harm him. Plus, why would I give my phone to Blair? We're not close.
And lastly, Ms. Cifuentes, I'd like to ask you, how did the defendant perform in their various roles on the mock trial team?
Avery is a fantastic actress and an amazing witness. She has this way of making you believe anything that she says.
No further questions, Your Honor.
Thank you, Ms. Langen. Any cross-examination of this witness, Ms. Fick?
Yes, Your Honor. Good afternoon, Ms. Cifuentes.
Good afternoon.
I'd like to first draw your attention to the day Detective Markowitz brought you in to interview. Now on the phone, you and the detective spoke about the text messages that you received from Avery, didn't you?
Yes, we did.
And you had to go into the station to interview about this?
Yes.
And on your way to the police station to interview about these text messages, you forgot your phone, didn't you?
Oh, yeah, everything was so crazy. The fact that my coach was had just been murdered, I was not thinking about my phone at all.
Sure. And the detective accepted these photos of text directly from you?
Correct.
The detective didn't ever try to physically retrieve your phone?
Well, no, they didn't. And I trusted the detective's judgment. They were professional.
And this phone is no longer in your possession, is it?
No, it's not.
This phone is not here in court today?
I mean, the text message screenshots are, and that's what was brought.
Now, you didn't provide the detective with these texts until a day after your meeting with them?
Well, I mean, I didn't even know who to call. After I heard the terrible news, I was in shock.
You didn't provide the detective with the text until a day after your in-person interview, did you?
Well, it was barely a day. I mean, yes, exactly, but it would have taken me that long trying to figure out who to call, and it just didn't come to mind right away. Again, I was in shock, and I was devastated.
Moving on, Ms. Cifuentes. Your Honor, may my co-counsel share Exhibit 14?
Yes, certainly.
Thank you, Ms. Johnson. Now, in the supposed screenshots, the first quote-unquote text from Avery states, "Hey, Alex, it's Avery," doesn't it?
Yes, it does.
And you've been on the mock trial team with Avery all 3 years, isn't that correct?
That's true.
And you've claimed Avery as your friend?
Yeah, we were really close.
Even your best friend?
I would definitely say that. We pushed each other in mock trial to do better.
And yet, in these screenshots, she begins her text by introducing who she is?
I mean, that was up to her, not me. That's how she said it. I consider it to be polite.
To clarify, it's common practice to introduce yourself to your best friend every time you text?
Well, whether or not it's common practice, I mean, I guess as a teenager, you could say I'm a professional at texting. And yeah, I would say that introducing yourself is polite, and we were talking about something serious. I didn't want to get the number confused or anything, so.
Sure. Now, Ms. Cifuentes, thank you, Ms. Johnson. You can stop screen sharing. You ran into Avery at the Fry Shack March 5th after she got kicked off the team.
Yes, I did.
And you played a game on Avery's phone?
Yes.
So you had Avery's phone in your possession that night?
Yeah, right, with Avery right next to me.
So you had access to her phone the night before the murder of Mr. Brackman?
Technically, yes, if that's how you want to phrase it, but just playing a game on a phone didn't mean much.
Sure. And you are aware that this phone is now missing?
Yes, that it did go missing at some point. I don't know, Avery didn't tell me about that.
But you do know this phone is now missing?
I do now, I didn't know then.
And you are aware that the phone was last seen in your hands that night?
Well, with Avery right next to me that I didn't take her phone.
Right, but the phone was last seen in your hands?
By me, it was last seen in my hands. I mean, after I gave it back to her, that was all.
Thank you, Ms. Fuentes. You know Blair Rollins, don't you?
Yes, vaguely.
Blair went to school with you?
Oh, well, yeah, we did go to school together, but we didn't have many classes at all.
Now, Detective Markowitz never asked you about Blair Rollins, did she?
No, she did not.
Detective Markowitz never asked you about any other suspect.
Why would she? I mean, like, she was just asking what I knew, and that was it.
Detective Markowitz never asked you about any other person besides Avery Becker, even with your extensive experience on the mock trial team?
I mean, the thing is I was close with Avery. I was not close with Blair, so there was no need to ask about anyone else.
So that's a no?
No.
Thank you. Now, Missy Fuentes, you are jealous of Avery's talent on the team, aren't you?
Oh, I mean, I definitely wanted my time in the spotlight. And I think I definitely wished that like Avery would share it a little bit, but like that was it.
Avery won a lot of awards for her experience for her mock trial.
Oh yeah, she did. But we were pretty equally skilled, so I wasn't lacking in the rewards category.
She would show up unprepared.
Yeah, it annoyed our team. Sometimes I just wish she'd joined debate club or something, but that was it.
Well, you would practice for hours and hours in front of your mirror.
Oh yeah, I take pride in my craft, and the coach could see that, and that's all the gratification that I needed.
You didn't think Avery deserved to be on the team, did you?
I think that she left our team in a state of anxiety because she would show up late a lot. And again, I just think that her skills could have been used elsewhere, but...
So that's a yes?
Yes.
And you asked Mr. Brackman on multiple occasions why he even put up with Avery's work ethic?
Well, I mean, Mr. Brackman and I talked, and that's definitely something we talked about, but it was me who asked Mr. Brackman to let Avery rejoin the A team for the sake of the team. So yes, we talked, if that's what you're asking.
And yet you yourself said you were happy she was off the team.
Again, I wanted my time in the spotlight. That does not mean I wanted her to go to jail.
You were excited for the bigger role that you would have at state.
I wouldn't have gone to state without her. We needed her.
But is that a yes? You were excited for the bigger role you would have at state?
Not at state. I would have had a bigger role next year, but she would have graduated anyways. We wouldn't have gone to state if Avery had been kicked off the team.
Is it your statement here today that you were not excited for the bigger role that you would have at state?
No, again, it is my statement that I was excited in future years, but if we couldn't go to state, what bigger role was there?
Missy Fuentes, you had a reason for Avery to be off the team for good, didn't you?
I mean, I had a drive, a passion for mock trial that I didn't always see that Avery and I shared. But again, like debate team or something else, that was it.
Thank you, Missy Fuentes. No further questions, Your Honor.
Ms. Langen, do you have any redirect?
Yes, Your Honor.
You may proceed.
Now, Ms. Cifuentes, why did you not provide screenshots of the text messages depicted in Exhibit 14 until a day after the murder of Mr. Brockman?
Again, it was the detective's job, not mine, to tell me if I should have brought the phone in, and the detective said I didn't need to, and I trusted their professional judgment.
Now, examining Exhibit 14 again, do you know why Avery would have introduced herself in the first line of your text message conversation?
Yes, because it was the polite thing to do.
And Ms. Cifuentes, did you take the defendant's phone?
No, I did not. I am too busy to be caught up in all of that drama.
And finally, Ms. Cifuentes, how would you describe your relationship with the defendant strictly on the mock trial team?
We pushed each other to do better. Although our work ethics were different, I appreciated the challenge. And again, we were friends.
No further questions, Your Honor.
Thank you, Ms. Langen. And thank you to you, Ms. Cifuentes. Ms. Misra, do you have a next witness?
Yes, Your Honor. The prosecution calls Ms. Kyle Cusack to the stand.
Thank you and welcome, Mr. Cusack.
Good afternoon,
Ms.
Ms.
Cusack.
Could you, oh, excuse me, Your Honor. Did you have something to say? I think I might.
No, go ahead. You may proceed.
Yes, Your Honor. Good afternoon, Ms. Cusack. Could you please state your name and spell your last for the record?
Yes, of course. My name is Kyle Cusack, Kuzak.
Now, can you please tell the court a little bit about your professional background?
Of course, I am a crime scene reconstructionist with 19 years of experience.
Can you explain a little bit what exactly is crime scene reconstruction?
Crime scene reconstruction, or CSR to be brief, is the process of analyzing pieces of evidence from crime scenes to find out what ultimately led to the results.
And where do you work right now?
For the past 3 years, I have been a civilian employee of the city of Denver.
And what have you investigated over your career working for the city of Denver?
Quite a variety of crimes, everything from homicides, fatal accidents, armed robberies, quite a variety.
What kind of processes do you use in these types of investigations?
I look at my personal work in 5 steps, those being recognition and documentation, evidence collection, evaluation, hypothesizing and testing, and then issuing my final peer-reviewed report.
Your Honor, at this time, the prosecution moves to enter Ms. Kyle Cusack as an expert in crime scene reconstruction.
Any objection to this witness?
No, Your Honor. All questions regarding the credibility of this witness will be addressed on cross.
Thank you, Ms. Murphy. You may proceed, Ms. Misra.
Now, Ms. Cusack, can you please explain to the court how you were involved in the case today?
Yes, I personally visited the crime scene where Mr. Brackman's body was found.
And what processes and investigation methods did you use in this specific investigation?
Well, I did use my usual 5-step method, and as per my usual work, I organized everything with various charts.
Now, elaborating on these charts, the trial technician will be screen sharing Exhibit 17. Ms. Cusack, do you recognize what Exhibit 17 is?
Yes.
What is it?
This shows my witness tracking sheet, evidence tracking sheet, and flowchart of the final sequence of events.
And how do you recognize what this piece of evidence is?
I created these documents myself.
And is this a part of your regular methodology in investigating these types of cases?
Oh, of course. I consider thorough documentation essential.
Is this commonly used in your field by other experts?
Yes, I wouldn't trust anyone who didn't thoroughly document the evidence they found.
And finally, is this a true and accurate copy of your work?
Yes.
Your Honor, at this time, the prosecution moves to enter Exhibit 17 into evidence.
Any objection to Exhibit 17?
No objection, Your Honor.
Exhibit 17 will be entered into the record. Please produce it to the panelists.
Yes, Your Honor.
Thank you.
Now, Ms. Cusack, referencing this exhibit, can you please explain to the jury what happened at its base during this crime?
Yes, well, if you look at the flowchart, which is color-coded, of course, we see that the main events which occurred here are the perpetrator traveling to the victim's residence, the victim noticing somebody attempting to enter his home, the two entering into a fight, likely over the knife that the victim armed himself with, and finally the victim being stabbed and tragically bleeding out in his own home.
Let's break that down a little bit more step by step. What happened initially as the home was entered?
Well, the perpetrator first attempted to enter through the front door, but eventually entered through the back, as indicated by the Ring security videos.
And what happened after that?
Well, the victim, either alerted by the Ring security system or simply hearing somebody attempting to enter his phone, armed himself with a knife from his kitchen.
What occurred after he armed himself?
Well, the two entered an altercation with one another, which I concluded based on evidence in the home, at which point the perpetrator ultimately gained control of the knife and stabbed the victim.
Now, the trial technician will be screen sharing exhibits 9 and 18. Ms. Cusack, do you recognize these exhibits?
Yes.
What are they?
Exhibit 9 shows a broken plate in the home, and Exhibit 18 shows scuff marks on the floor of the victim's home.
And how do you recognize what these pieces of evidence are?
I observed them myself at the crime scene.
And are they fair and accurate representations of what you saw at the crime scene?
Yes.
Your Honor, at this time, the prosecution moves to enter exhibits 9 and 18 into evidence.
Counsel, are there any objections to exhibits 9 and 18?
No, Your Honor.
Both exhibits will be published to the jury. They are admitted into evidence. Thank you.
Yes, Your Honor. Now, Ms. Cusack, can you please explain to the court why these pieces of evidence were important in your investigation?
Of course. Well, we obviously know that the perpetrator entered through the back door, and those are some of the scuff marks shown near that door. And we understand that the fight traveled sort of through the kitchen, at which point the plate was knocked over.
Now, let's talk a little bit about the murder weapon itself. Can you please explain to the court where this knife came from?
The knife came from the victim's own home.
Now, the trial technician will be screen sharing exhibits 5, 7, and 8. Do you recognize what these exhibits are?
Yes.
What are they?
These are images of the knife and the knife block found in the victim's home.
And how do you recognize what these exhibits are?
I observed them myself.
And are these pictures fair and accurate representations of what you saw at the crime scene?
Yes.
Your Honor, at this time, the prosecution moves to enter exhibits 5, 7, and 8 into evidence.
Any objections to these 3 exhibits, counsel?
No, Your Honor.
The exhibits will be admitted into evidence and may be published to the jury.
Yes, Your Honor. Now, Ms. Cusack, can you please explain to the court what analysis you gathered from these pieces of evidence about the murder weapon?
Of course. Well, Exhibit 5 shows what the murder weapon actually was, and how it was found in the home. But Exhibit 7 and 8 show the other knives present in the victim's kitchen. And the knife drawer was open at the scene, indicating that the victim searched for a defensive weapon in there, but he also could have taken it from the knife block.
So based on this evidence that you found, was it likely that the knife came from the victim's house?
Yes.
Now, referencing Exhibit 4, which has already been entered into evidence and will be screen shared by the trial technician, can you please explain to the jury what important analysis you gathered from this piece of evidence?
Well, we can clearly see that the knife wound here is horizontal, which to me indicated that more evidence that the victim was stabbed in a sort of bear hug position, where the perpetrator and victim were facing one another, and the perpetrator, holding the knife horizontally, used his arm as a sort of hinge in order to get the force to puncture the victim's body.
And is there any, excuse me, can you please elaborate a little bit on the evidence and analysis that you used to come to the conclusions that you did in this case?
Well, we clearly saw from the Ring security videos that the perpetrator entered unarmed. We could see both hands free, as well as the fact that the victim had quite a number of knives in his own kitchen. So it seems fairly clear that the perpetrator entered the home not intending to harm Mr. Brackman.
And in your expert opinion, given the evidence that you analyzed, who is the perpetrator in this case?
Avery Becker.
Thank you, Your Honor. No further questions at this time.
Any cross-examination of this witness?
Yes, Your Honor.
You may proceed.
Good evening. You say that you approach crime scene reconstruction in 5 steps, correct?
Yes.
Let's go through that process one by one. When you arrived at the scene to complete your recognition and documentation step, the crime lab had already processed the evidence, right?
Yes, I am a civilian employee, not a police officer.
Which means that you didn't have fresh eyes on the scene.
Well, I'm not a forensic specialist. They arrive on the scene first. I came in later.
So the evidence could have been ruffled around with, and you wouldn't know because you didn't see the crime scene firsthand.
Well, I do not believe that the police department I work for would at all interfere with the evidence. We simply try to find out the truth about what happened in this murder.
The second step in your process was the collection of evidence, correct?
Yes.
However, in all your apparently meticulous work, the digital files for the photographs of the crime scene became corrupted.
That occurred far after my analysis, and I did observe the blood splatters at the crime scene, but yes, that did occur.
But this means that the photograph evidence the jury will review today is not an accurate depiction of the crime scene.
Well, the blood splatters were hardly the most important piece of evidence to our investigation.
Are you saying that the blood splatter photos are the only photos that were corrupted?
Well, yes, I believe so.
Are you aware that you made a statement prior to court today?
Yes.
And in that statement, you state that all of the photos were corrupted, not just the blood droplets and their cast-off splatter?
Well, we obviously have photographs from the crime scene in the form of the broken plate, knives, and scuff marks that are present today.
Yes, and all of those photos of the crime scene were corrupted, correct?
Eventually, but I mean, we have backup copies which are obviously present in court today.
Objection, Your Honor. I believe that opposing counsel is trying to improperly impeach the witness.
Any response?
Your Honor, I was just trying to confirm the witness's response in coordination with her statement.
Counsel, proceed with your questioning, but be careful with how you phrase those questions.
Yes, Your Honor. In addition to those corrupt photos, you also managed to lose images of the blood droplets and their cast-off splatter during your collection of evidence, correct?
That did occur after my analysis, but yes.
And they are not here today for the jury's review so they can render a fair verdict?
Well, they are not, but they were not as I said earlier, they were not any key piece of evidence to me.
The third step in this process was the evaluation of evidence, correct?
Yes.
And in this process, you analyzed the scuff marks in Mr. Brackman's home?
Yes, I did.
And in your evaluation, you determined that this evidence indicated a fight between the intruder and Mr. Brackman?
Yes, that was my conclusion.
And you never make assumptions without evidence, correct?
Well, in crime scene reconstruction, we can only base our theories off of what evidence is present. And yes, I would say that I made conclusions based off of the physical evidence present.
Yet you assume that these scuff marks indicated a fight when they could have been created at any point, correct?
Well, we very clearly see that they are incredibly dark scuff marks, which would only really occur due to very forceful motions. There is no form of dating scuff marks, which I could have done, but I highly doubt that they would have otherwise occurred.
Well, exactly as you said, carbon dating, which is the only thing that would determine the time where they were created, was not possible, correct?
No.
So for all we know, those scuff marks could have been created a year ago when Mr. Brackman just came back from a hike.
Possibly, but I doubt it.
Secondly, in your evaluation of evidence, you determined that the Ring doorbell notified Mr. Brackman of the intruder.
Either that or having simply heard somebody attempt to enter his home.
Yet again, you assumed Mr. Brackman had his notifications turned on when they very well might have been turned off.
I did believe that, but even if they were turned off, he still would have heard somebody enter his home.
But that's just another assumption, isn't it? Because you don't know if Mr. Brackman heard someone enter his home.
It is incredibly likely, and based off of the knife coming from his own home, it is what I concluded.
But it's an assumption.
Yes.
And you didn't even take the time to confirm your theory of the Ring doorbell notifications by checking Mr. Brackman's settings, did you?
Well, I am a crime scene reconstructionist and not any kind of technical expert. I simply worked out of the evidence I was given.
But it wasn't a priority to confirm your theory?
Well, based off of the other evidence I'd collected, I was fairly certain of my theories.
Then your fourth step was hypothesis and testing, and then your fifth was reconstruction, correct?
Yes.
Now you say that after completing this step, that the evidence you collected could only lead you to one conclusion.
Yes, that is correct.
So you knew this case for sure if it led you to a solitary conclusion.
I would believe so, yes.
Just like you were absolutely confident in your recollection of lost and corrupted photographs?
Well, as I stated earlier, that if you're referring to some of the corrupted files, we have copies of many of them, and the blood splatters were not key to my case.
And just like you were absolutely confident in the Ring doorbell notifications?
Well, it was either that or simply hearing somebody enter his home.
And just like you were absolutely confident in your analysis of the scuff marks?
I am confident in my analysis. I have 19 years of experience in my field.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any redirect?
Yes, Your Honor.
You may proceed.
Yes, Your Honor. Ms. Cusack, did the blood splatter images that were lost have much of an impact on your findings today?
Not particularly. The key pieces of evidence to me were the scuff marks, where the knife came from, and the broken plate.
And what led you to the conclusion that the scuff marks occurred because of the struggle at the murder?
Well, I mean, we can see from the images and from what I observed at the crime scene, those are very dark scuff marks. That only generally comes from very severe actions, as you might see in, say, a basketball court where people are moving very quickly and very forcefully.
Now, why was it likely that Mr. Brackman was aware of the intruder entering his home?
Well, either he did have his Ring notifications on, or he heard the perpetrator travel to his house, first attempt to open the front door, fail to do so, and then walk around the back and open the back door.
Now, did you have enough strong, conclusive evidence to come to a conclusion in this case?
Of course, I consider it essential to the crime scene reconstruction professionals considered my work sufficient.
And in your expert opinion,
I'm sorry, this could have been on my end, but it appeared that the internet cut out. I would ask that the witness repeat her previous answer.
I agree. I did not hear the witness, the last few statements.
Your Honor, I believe we only have
the attorney's moving, so it wasn't my internet.
I apologize. That was likely an internet issue on my end.
Your Honor, since the time left on this questioning is nearing its end, I would ask that we simply have a few seconds back so that Ms. Cusack can repeat her answer.
Certainly, put 20 more seconds on the clock.
Yes, Your Honor. Ms. Cusack, would you like me to re-ask the question?
Yes, please.
Did you have enough strong, conclusive evidence to come to a conclusion in this case that you were confident with?
Of course, I would not publish any of my work unless I considered it complete. And since my final reports are peer-reviewed, obviously other professionals saw my evidence and investigation as thorough as well.
And in your expert opinion, who is the perpetrator in this case?
Avery Becker.
No further questions, Your Honor.
Thank you, counsel. Thank you, Ms. Cusack. Does the prosecution rest at this time?
Yes, Your Honor. The prosecution rests.
Thank you. Is the defense ready to put on their case?
Yes, Your Honor. The defense calls Professor Van Owen to the stand.
Thank you, Ms. Murphy. Professor Van Owen, you are reminded that you are under oath.
Yes, Your Honor.
Ms. Murphy, you may proceed.
Thank you. Good evening, Professor Van Owen. Would you please state your full name and spell your last for the record?
Hello, I am Professor Blake Van Owen, Van Owen.
And what do you do for a living?
I've worked for the Aurora PD as a security guard and as a school resource officer. Now I'm a professor. My journeys have led me to a community college, and now I work at CU.
Where did you receive your education?
Well, I received my bachelor's in English right here in Colorado at Boulder, and a criminal justice major from Ashford University.
You mentioned that you are a professor. What do you teach?
I teach in everything ranging from police procedures, police practices, and most importantly, social justice.
Have you ever used your experience to testify as an expert witness?
Absolutely. I avail myself regularly as an expert courtroom witness. I've consulted on over 100 cases thus far. I've also been an expert for courts in 6 different states. I get to use my expertise everywhere from the canyons to the Rockies.
What areas have you testified to as an expert witness?
I testify from everything ranging from crime scene reconstruction, cell tower analysis, and general police practices.
How many times have you testified in each of these areas?
Yeah, let me break that down. So crime scene reconstruction 8 times, cell tower analysis 5 times, and general police practices 12 times.
What are the methods that you use to determine the facts of a case?
So anything ranging from police reports, crime scene reconstruction, and cell tower reports.
Did you use these methods and prior expertise to conclude your investigation in today's case?
I absolutely did. It's like you're talking to a beekeeper about bee care, honey extraction, and hive construction. This case is the wheelhouse of my expertise.
Your Honor, because of Professor Van Owen's extensive experience as a defense expert, we would like to enter her in as an expert witness in crime scene reconstruction, cell tower analysis, and general police practices pursuant to Rule 702.
Any objection to this witness?
No objection, Your Honor.
Thank you. You may proceed.
Have you
The
reviewed-
witness is accepted as an expert in those fields.
Professor Van Owen, have you reviewed the police's opinion in today's case?
I absolutely have, backwards and forwards.
Do you agree with their opinion?
I disagree wholeheartedly. Numerous areas were either overlooked or completely botched.
Which areas in the investigation were overlooked?
Well, I've organized their flaws into 3 categories. The attack, the opportunity of the intruder, and the carelessness in the collection of evidence.
Let's look further into those points. Could you start with the attack?
Certainly. The police believe that the victim anticipated the intruder's attack, and there was some kind of struggle between the two. This was based on, get this, Ring doorbell alerts and scuff marks on the floor.
Were these reliable indicators?
Absolutely not. The police failed to see if the victim even had Ring alerts. It was a very simple check, but the police just assumed. It is very likely they were turned off.
You also mentioned the scuff marks. Could you elaborate to those a little bit more?
The police never even dated the scuff marks. They have no idea when they were made or what they are from. Without this information, they are just scuff marks of doubt.
In lieu of this information, what did you find to be the most likely scenario?
The victim was clearly sitting at the table, unaware of the intruder. The intruder stabbed him from behind and fled the scene.
The second point that you mentioned was the opportunity of the intruder. Why did you find the police overlooked this area?
Well, to start, the height of the intruder was entirely disregarded.
Why does the height matter?
If you look at the photos, the victim was clearly a large, full-grown man. For the prosecution's theory to work, the intruder would have to be standing above him to stab Avery at that downward angle, while the victim was also upright. Avery, while the victim was upright, could clearly not stab a full-grown man.
Was there any other detail in this area that the police miscalculated?
Yes, the police relied on the unpredictable cell tower reports.
Why are they unpredictable?
Think of a cell tower like a glass of water, or filling up a glass of water. When one glass gets too full, you move on to the next. Same goes for cell phones. When one tower doesn't provide the best signal, it moves on to the next one. This connection pattern is impossible to predict. A phone could sit under a sofa for hours and connect to several different towers.
And why is the cell tower information crucial?
The police, once again, assumed that this map could show the location of Avery, but as I said, cell towers work nothing like a GPS, and phone GPS data was not provided by the police today.
The third and final point you mentioned was the carelessness in the collection of evidence. Could you elaborate?
On top of everything, photos of supposed blood drops around the house were corrupted. The police entirely lost a set of evidence from the crime scene.
Is there any other information that the police did not investigate?
Yes, the police failed entirely to consider other suspects, specifically Blair Rollins.
Who's Blair Rollins?
Blair is a former CHS student. Her father was sent to jail after the victim represented him in trial.
Was Blair questioned by the police?
Blair Rollins was not questioned by the police. Let me say that again. Blair, someone with a clear motive against the victim, was not located or questioned by the police.
Overall, what are your conclusions about the police's investigation?
Simply put, the police have no files, no phone, and no felony. This investigation was rushed, and Avery Becker has been wrongfully accused.
And why are the 3 key details that we discussed today so important?
These points are the foundation of the prosecution's case. They're as pivotal as the axle of your car when you're going 90 miles an hour. If you're going to put someone on trial for murder, it is your burden to prove every single detail correct. The details of the prosecution are just far from correct.
Thank you, Professor Van Owen. No further questions, Your Honor.
Thank you, counsel. Any cross-examination of this witness?
Yes, Your Honor.
Proceed.
Now, Ms. Van Owen, you used to work for the Aurora PD, correct?
I did, yes, for a 9-month period. I did.
But you left and now work as a private investigator.
I do. I proudly do. Yes.
Where you are paid much, much more than your previous job.
That's not in my statement. Would you like me to answer anyways?
Yes, I would. You are paid more, correct?
I don't know about my payment prior to in the Aurora PD. However, yes, I am paid for today.
In fact, you have charged over $7,000 for the current case today.
Yes, I do get paid to do my job.
And you expect that you will be paid up to $1,000 more after your testimony here today in court.
Yes, I do get paid to do my job.
And you will be paid this certain amount, correct?
Yes, I do get paid a certain amount to do my job.
Now, you do not like Detective Markowitz very much.
Objection, Your Honor. Relevance.
Counsel, can you address the relevance in this case? I mean, in this question?
Yes, Your Honor. This line of questioning is simply to establish bias or lack thereof that the witness has towards the prosecution.
Any response, Ms. Murphy?
Your Honor, I still don't see how the professional relationship between 2 people is relevant to the murder trial here today.
I'll allow a little leeway with this question. You may proceed.
Could you please re-ask the question?
Yes. You do not like Detective Markowitz on a personal level very much, do you?
Correct. I don't like people who don't take their job seriously and go thorough with their work.
But you let it get so far as letting it affect your professionalism, and you call her Defective Markowitz.
Freudian slip. Yeah, I don't appreciate it when people don't go thorough in an investigation. So no.
So you had and left a Freudian slip in a signed affidavit for the court.
Yes, I did.
Now, much of your case today seems to be trying to disprove the detective's claims. So let's go through one. You claim that Blair Rollins had the motive and opportunity to kill Coach Brackman.
Blair Rollins did have the motive and opportunity to kill Coach Brackman.
And you were unsatisfied with the police's investigation of Mr. Rollins.
Correct. The investigation is incomplete and Avery Becker has been wrongfully accused.
And so you took it upon yourself to complete this investigation.
I did, absolutely. And my investigations show that Blair Rollins had a clear motive.
And you did so much investigation that you found out Blair Rollins' height and build.
I did, yes. I was able to retrieve this from yearbook photos.
And you did the work to track down an audio clip of his father.
Yes, I was able to find that from a prior court statement.
And you even found attendance records from the day of the crime.
I did. Blair Rollins was not at school on the day of March 6th, Mackenzie Brackman's murder.
But despite all of this work, you failed to obtain cell phone records, which would have placed Mr. Rollin at the scene of the crime.
If you're referring to cell tower records, then no, that would not have placed Blair Rollins at the crime, as cell tower records cannot be used to show the location of anyone.
But you did not find any type of cell phone record that would have indicated whether he was even in the vicinity of the crime on the day of the murder.
No, I consider this the job of the people with the burden of proof.
And you were not able to find him despite your investigation methods.
No, I was not able to locate Blair Rollins, nor did the police attempt to investigate or question Blair Rollins.
Now, let's move on a little bit to the crime scene itself. You claim that Coach Brackman was sitting down at his kitchen table when he was murdered.
Yes, Coach Brackman was sitting down, intruder came in from behind, as I said.
So let me just walk the jury through what that means. That means that the intruder would have had to try and enter through the front door, which triggered the ring security system. And after
yes,
that,
I'm not.
Your
Sorry,
Honor,
I'm not exactly sure what you.
Excuse me. Your Honor, I would prefer that the lawyer or opposing counsel did not testify and instead ask my witness questions to confirm this theory.
Please re-ask the question, Ms. Misra.
Yes, Your Honor. So that means that the intruder would have had to enter the home through the front door, which triggered the ring security system, correct?
No, they entered in through the back door, and I'm not sure what you mean by triggered the ring security system. However, there is ring video footage that was captured by cameras.
But they did attempt to enter the home from the front door, correct?
They did attempt to enter. However, that wasn't the an unlawful place of unlawful entering. No.
And after this failed attempt, they moved and entered the home through the back door.
As I said, yes, they entered through the back door.
And this once again triggered the ring security system, which caught a video of this.
I'm not sure what you mean by trigger the ring security system. However, the cameras were able to capture that motion on camera.
And so the perpetrator then moved into a house that they had never been in, correct?
I'm not sure if the perpetrator had ever been in the house before.
And after they entered the home, they snuck up on the victim and stabbed him in the back.
Absolutely, yes.
And so you're claiming that during all of this commotion, Coach Brackman simply stayed seated at his kitchen table with his back to the door?
Yes, that's absolutely what happened. The intruder came in from behind, though it was very quick, stabbed him, Brackman stood, the intruder fled the scene.
Now, the trial technician will be screen sharing Exhibit 21.
Just to let you know, I've got a copy in front of me. I'm a very visual person.
Good. Now, this piece of evidence is from the report that you created for today's case, correct?
It is, yes, certainly.
And you recognize it because you made this document yourself.
I did create this. I took this photo, yes.
And this is a true and accurate copy of your work.
Absolutely.
Your Honor, at this time, the prosecution moves to enter Exhibit 21 into evidence.
Any objection?
No, Your Honor.
The Exhibit 21 will be admitted into evidence and published to the jury.
Now, Ms. Van Owen, you state that the murder weapon in this case was held in the way shown in this picture, correct?
Yes, exactly. It was held in a downward motion so that it could come at a stabbing angle from above the victim who was sitting at the table.
And just to clarify, the knife is being held point first with the blade vertical.
I mean, in this picture, the blade is vertical. However, that's just showing the hand position rather than specifically the knife position. I was showing the orientation of the blade. So, yes.
But you still state that the knife was held in this manner in a normal stabbing motion, similar to the movie Psycho.
Yes.
Which resulted in a vertical knife orientation.
Yes.
And you claim that holding the knife in this manner would result in a wound matching that of the victim's.
Absolutely.
Now directing you to Exhibit 4, which the trial technician will be screen sharing. This knife wound is clearly horizontal, correct?
Hang on, I'm just going to pull up a version. Oh, yep, got it right here. Sorry, could you repeat that question?
Yes. The knife wound on the victim is clearly horizontal, correct?
I relied more on the autopsy report rather than a photo. However, it appears that there is also a vertical component to this stab that is about 90 degrees from the horizontal component I believe you're referring to. The blood and angles of the lighting make it a little bit hard to refer to using just a photo.
But clearly the bigger mark is the horizontal one, which spans the width of the blade, correct?
I wouldn't say the bigger mark. There are clearly two distinct marks, a horizontal one and a vertical one, and I relied more on the coroner's report.
Now, moving to the way that the victim would have had to bled out. In the coroner's report that you so heavily used, the knife nicked the aorta, meaning there was severe internal bleeding, correct?
Correct, yes.
Which means
sorry, could I clarify? The severe internal bleeding came from when the knife was removed from the shoulder blade. However, it was nicked when the heart was stabbed.
Correct. And because of this heavy internal bleeding, the victim died very quickly, correct?
Yes, as pursuant to the coroner's report.
Exactly. So that means that according to your summary of this murder, the victim was sitting at his kitchen table and got stabbed, correct?
Correct.
And then he pulled the knife out of his own shoulder and then stood up and walked to his front door, correct?
Yeah, I would assume that would take anywhere from 5 to 10 seconds.
For the victim to completely get up and move himself across the width of his house?
My apologies. I'm not completely sure of the width of the house. However, I would assume that this time was not extremely great.
So the victim was able to still move while they were bleeding out from this heavy internal bleeding?
Yes, they were. I would imagine it's painful. However, yes.
I have no further questions at this time, Your Honor.
Thank you, counsel. Any redirect?
Yes, Your Honor.
You may proceed.
Professor Van Owen, do you expect to be paid for your job?
Absolutely. I am paid for my time today.
And do you have a professional relationship with Detective Markowitz?
I do, yes. I have seen his prior testimonies and prior research tactics. I don't particularly agree with them, as in today's trial, I've shown you, I have checked on the police and this investigation was botched.
And why is Blair Rollins a more probable suspect?
Someone's dad being sent to murder on behalf of someone is far greater than someone being kicked off a team.
Thank you, Professor Van Owen. No further questions, Your Honor.
Thank you, counsel. The witness is excused. Ms. Hayden, please call your next witness.
Yes, Your Honor. The defense calls Avery Becker to the stand.
Thank you. The witness is reminded that she is under oath. You may proceed, counsel.
Good evening, Ms. Becker. Could you please state your full name and spell your last for the record?
Avery Becker, Becker.
Avery, how do you know Mr. Brackman?
Mr. Brackman was my mock trial coach while I was a student at Colorado High School.
And could you describe your relationship with him?
Unfortunately, Mr. Brackman and I didn't always get along very well. I loved mock trial and I was good at it too, but Brackman always seemed to think I was lazy just because I didn't need to prepare very much.
Would you say that Mr. Brackman is a good coach?
In my opinion, not really. Mr. Brackman was always very controlling and demeaning. He would take over most of the students' work and then end up spending half the practice talking about himself or his Porsche.
And Ms. Becker, can you inform the jury of your relationship with Taylor Perkins, please?
Taylor is my best friend. We decided to do mock trial together as a way to get out of the house and see one another more often.
So tell me about last year's mock trial season. That was your senior year of high school.
Yes, unfortunately, it wasn't great. Mr. Brackman assigned me the role of doing the closing and of crossing the expert witness, two roles that are both pretty big, but that didn't stop him from trying to completely take over everything and rewrite all of my scripts.
And what happened before the regional competition of last year?
Yeah, about a month before the regional competition, I showed up at practice one day, only for Mr. Brackman to once again tell me that he didn't think I'd prepared enough. Before I could even defend myself, he demoted me to the B team.
And so what did you do?
Well, I knew that I deserved my position on the A team and that I had worked hard for it, so I was a little bit upset. But Taylor, who, if we're being honest, wasn't all that into mock trial anyways, came up with the idea that if she quit the team, Mr. Brackman would be forced to let me back on, and luckily he was.
So this plan to get you back on A team was successful.
Yes, everything worked out in the end.
So then how did the regional competition end up going?
It went great. Mr. Brackman put me back on the team in my original spots, and I ended up winning Best Attorney and Best Closer.
With these new accolades, did the way that Brackman treated you change?
Unfortunately, no. On the very next Tuesday after regionals, Mr. Brackman was right back to his same self. He said that he didn't think I deserved the awards I'd won and that the team's success was only thanks to the scripts that he had practically written and not due to our hard work. He even said that I just relied on my good looks and was lucky.
And what did you say to this?
Well, I retorted that he couldn't keep taking credit for all of our hard work, and I was actually pretty upset, so I ended up storming out of the practice.
And what happened when you stormed out?
When I got to the parking lot, I saw Mr. Brackman's car, and I was also holding an expo marker, well, what I believe to be an expo marker, as I'd been about to take notes on the whiteboard about regionals.
And what did you do with the marker?
I did the dumbest, most immature thing I've ever done, and the worst mistake of my life. I used the expo marker, or dry erase marker, to write on Mr. Brackman's car, Worst Attorney Award. I guess I had no idea that it was a permanent marker, and regardless, it never should have happened. I feel awful about it.
How did your coach react to seeing his car?
Well, Mr. Brackman then walked out to the parking lot. I think he was trying to talk to me about the argument we just had, but when he saw the car, he exploded, yelling at me that I was off the team for good and even calling Taylor a loser.
And so what happened next?
Yeah, well, after that, when I got home, I was sobbing. I was just so upset that my mock trial career was over for good. But I ended up talking to my mom about it. I left out the part about the car, but I told her everything else. And she gave me some really good advice and helped me to just calm down and realize that the best thing to do was apologize and be honest about the whole situation.
With your mother's advice and just in general with hindsight, how do you feel about the car incident?
Almost immediately, I just felt so much regret and felt awful about the whole situation. So I went to Mr. Brackman's in person to try to apologize. I texted him. I even offered to scrub the car, and I said that if that didn't work, I could get a job to pay for repainting. I would have done anything to make things right with him.
Was Mr. Brackman ever able to accept your apologies?
No, Mr. Brackman refused to see me in person and never answered any of my texts.
So let's discuss the evening of March 5th. What did you do?
Yeah, so Taylor and I, we went to the Fry Shack where we saw a bunch of the other mock trial kids, including Alex Fuentes. While we were there, Alex had my phone a bunch playing games on it. And then after that, Taylor and I went to the mall to walk around.
And tell me about your relationship with Alex Fuentes.
Alex Fuentes and I are not friends. We've never really gotten along all too well, and we don't spend time with one another or text or anything like that.
And so your senior year of mock trial last year, would you say you texted Alex Fuentes often?
No. I heard Alex lie on the stand earlier and say that I texted her trying to get back on the team, and even that I told her I was going to trash Brackman's house, but I never did either of these things, and I never would. I've never texted Alex for any reason, let alone to say something as awful as that.
So these screenshots that we heard earlier in court today, are those real?
Absolutely not. I have never texted Alex Fuentes for any reason, and I would never do anything like that.
And you heard Detective Markowitz say that the only evidence of these texts were screenshots, didn't you?
Yes, exactly, because I never sent these texts, so how could they have any other evidence?
Absolutely. What did you notice when you woke up on the 6th?
Well, when I woke up on March 6th, I immediately noticed that my phone had gone missing.
And so what did you do about it?
Well, I knew that the last time I'd seen it was at the Fry Shack, and so I picked up Taylor and we decided to go look for it. We also checked the mall just to be safe, but we kept using Taylor's phone to call it, but every time that it would ring, it would hang up really quickly, which kind of led us to think that maybe it was lost or somebody had stolen it.
And was your phone ever found?
No, it hasn't been found.
Miss Becker, do you know who Blair Rollins is?
I do. Blair Rollins is a student who went to Colorado High School at the same time I did.
And do you know what Blair Rollins looked like?
Approximately, yes. Blair was just about the same size and build as I am.
Do you know if Blair Rollins knew Mr. Brackman?
Blair definitely knew Mr. Brackman. Mr. Brackman was the attorney that lost the case that got Blair's dad sent to jail. In fact,
Objection, Your Honor. Speculation. This witness has not laid foundation for how they would know this case.
What's the response, please?
Your Honor, was it a speculation objection or a lack of personal knowledge objection?
I think both, but Counsel, Ms. Langland, would you like to elucidate on that?
Yes, Your Honor. It was yes to both of those speculations. Seeing as counsel has not laid foundation for the witness's knowledge, this does in fact call for speculation.
There's your objection, counsel. Do you have a response?
I can lay more foundation about how my witness knew this information, but she is not speculating in any way, Your Honor.
You may proceed.
Avery, what do you know about Blair and Mr. Brackman's relationship, and how do you know it?
right. So yeah, like I said, Blair was a student at my high school, and pretty much everyone knew about the whole situation between him and Mr. Brackman. Basically what happened is Mr. Brackman was the attorney that lost the case that got Blair's dad sent to jail. And from what I observed, Blair really hated Mr. Brackman more than anyone.
So Blair would have a reason to get revenge on Mr. Brackman.
From what I know, absolutely. Blair despised Mr. Brackman.
And where's Blair now?
No one really knows. Blair's just kind of disappeared and no one's heard from him.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any cross-examination of this witness?
Yes, Your Honor.
Proceed.
Good evening, Ms. Becker. You were good at mock trial.
Yes, it was something that I loved and had a lot of fun with.
Mock trial and putting on a performance comes naturally to you.
Mock trial did, yeah. I was pretty good at it. Like I said, I won some awards and it was an extracurricular that I enjoyed a lot.
Because you were naturally good at mock trial and putting on a performance, you did not have to work very hard.
I don't know if working hard is the right term. I guess you could say that I didn't have to maybe prepare a lot just because it did come pretty naturally to me and I was good at making things up on the fly.
Yes, and your lack of preparedness, which was perceived as laziness on Mr. Brockman's part, is one of the reasons why you did not get along.
Yeah. Well,
Objection, Your Honor.
What's the objection?
This question asks my witness to speculate to the feelings of Mr. Brackman, which she cannot do.
Ms. Langdon?
Your Honor, I'm simply asking the witness to testify to her relationship with Mr. Brockman. I did not ask her to speculate as to the feelings of Mr. Brockman.
Would you rephrase the question, please?
Yes, Your Honor. You did not get along with Mr. Brockman.
At times that is true. Mr. Brackman and I were just very different people and had pretty different personalities, which led to occasional clashes between us. It was just a matter of, I guess, styles, you could say.
Yes, you did not like Mr. Brockman even.
Once again, at times that was the case. Mr. Brackman actually did a lot for our team, and I don't necessarily think I always gave him enough credit for that, but it's true that in terms of personal relationships, we didn't get along all too well.
In fact, Mr. Brockman never gave you credit for anything that you did.
That was a common occurrence. Like I said, with the whole regionals award thing, he just seemed to have a lot of a lot of criticism, but once again, it was just differences in styles. He didn't like that I went off scripts. I wasn't always a fan of how scripted he was.
Yes, thank you. I will come back to that momentarily. Mr. Brockman always criticized your work. Yes.
As I just said, yes, at times he could be very critical.
Mr. Brockman, just to clarify, always criticized your work.
Once again, yes, Mr. Brockman was often quite critical of my work.
You argued with Mr. Brockman at almost every single practice.
Yes, I don't know that I would say all, but it was a pretty common occurrence, yes.
You told Mr. Brockman that he wouldn't know a good cross if it hit him over the head.
Yeah, that was the kind of thing that happened between us, little altercations, but honestly saying that I was probably wrong. I didn't give him enough credit, and he actually did a lot for our team.
Mr. Brockman demoted you from the A team to the B team a month before the regional tournament.
He did, but luckily it all got figured out and I ended up back on the A team, so it wasn't that big of a deal.
Yes, I'm glad you mentioned this reinstatement. We will also revisit that later. After winning the Best Attorney Award and being named Best Closer at the regional mock trial tournament, Mr. Brockman criticized your accomplishments and even went so far as to say that you did not deserve them.
That's true. He said that I was just lucky and that I just relied on my good luck, which I guess was sort of a compliment, but yeah, like I said, he was pretty critical at times.
You became really angry as a result of these comments.
At the time, absolutely, I was upset. I mean, who wouldn't be when you're being constantly criticized by someone who's supposed to be a mentor?
In fact, you stormed out of practice.
On one occasion, I did leave practice, yes. Like I said, it was just hard with the constant criticism.
Then, after storming out of practice in this particular instance, you wrote across the hood of Mr. Brockman's Porsche Worst Attorney Award, correct?
To clarify, I had no idea it was a permanent marker. I honestly believed it to be an expo or a dry erase, but nonetheless, that does not make it excusable, and I feel awful about the whole situation. I wish I could make it right with Mr. Brockman.
And now, just to further clarify, despite what you believed the marker to be, it was in fact a permanent marker used to vandalize Mr. Brockman's Porsche.
Once again, I turned out to be wrong, but when I did the drawing, I honestly believed it to be a dry erase marker or an expo marker and had no intent of harming his car.
You then went home and lied to your mother about the reason why you were kicked off the mock trial team.
I wouldn't say I lied to her, no. I perhaps left out some of the details about the car. It's not really the kind of thing you want to tell your mom, but I told her pretty much everything else.
You told your mother that you did not know the reason why you were kicked off the mock trial team.
I did tell her that it seemed silly and, I guess at the time it did to me, but looking back on it, I was totally in the wrong and I regret the whole situation. And luckily my mom helped me come up with really great ways to apologize and just try to make things right with Mr. Brockman.
Yes, you even vowed to get back at Mr. Brockman if it was the last thing you did.
After the incident, while I was still quite upset, those were the words that came out of my mouth, but I didn't mean anything by them, and I almost immediately
Ms. Becker, that was not my question. I simply asked, you said the words, you would get back at Mr. Brockman if it was the last thing you did, yes?
As I already said, yes, those words were the words.
Now, moving on to your best friend, Taylor Perkins. You consider yourself best buds with Taylor Perkins.
Yes, Taylor and I are best friends. We did mock trial together.
Yes, in fact, Taylor Perkins is one of the reasons that you decided to join mock trial in the first place.
One of the reasons, yeah, it's the kind of thing you do with a best friend, come up with things to do together.
Yes, and you are such good friends with Taylor Perkins that Taylor Perkins stepped down from her position on the mock trial team in order to reinstate you back on the A team.
Well, here's the thing. I just want to clarify that Taylor really wasn't all that into mock trial. It just wasn't her thing. So it ended up not being a big deal at all.
But Taylor Perkins did step down from her position on the mock trial team, and as a result, you were reinstated on the A team.
Once again, yes, but Taylor really wasn't all that into mock trial, so it wasn't a big sacrifice or anything.
Ms. Perkins is your alibi for the day of March 6th or the murder of Mackenzie Brockman.
Well, she is the person who I was with. I mean, I don't know about alibis or anything, but she's the person who I was with on March 6th, correct?
Taylor Perkins is the only person who can vouch for your whereabouts the entirety of the day of March 6th, 2020.
Objection, Your Honor.
What's the objection?
Lack of personal knowledge. I believe that Ms. Langen is asking my witness if anyone else saw her on March 6th, which she has no way of knowing.
Counsel?
Your Honor, I believe the phrasing of my question was the entirety of the day of March 6th. I did not ask whether or not anyone else had seen them, simply whether or not Ms. Perkins was the person with Ms. Becker the entirety of the day of March 6th.
The objection is overruled. You may proceed with the question.
Now, Ms. Perkins, let me ask this again. Excuse me, Ms. Becker. Ms. Perkins was the only person who was with you for the entirety of the day of March 6th and the only person who can vouch for your whereabouts for the entirety of March 6th.
Your Honor, I stand by my objection. She is asking if anyone else can vouch for Avery's whereabouts, which Avery is not aware of.
Would you like to rephrase that question, counsel?
Your Honor, I still do not understand counsel's objection, seeing as I am using the word entirety of the day, not contradicting the fact that someone else might have seen them, but specifying for the entirety of the day.
Is the witness able to answer the question?
Yes, Your Honor, I do believe the witness should be able to answer this question.
No, I'm asking the witness.
Yes.
My apologies.
Ms. Becker, can you answer the question as stated?
I believe I can proceed, yes.
Yes, go ahead.
Would you mind restating the question just one more time to make sure I'm entirely clear?
Yes, Ms. Becker. So Ms. Perkins is the only person who can vouch for your whereabouts the entirety of the day of March 6th.
Right, so if I'm...
No further questions, Your Honor.
I never...
Then do you have any redirect of this witness?
Yes, Your Honor, briefly.
Proceed.
Ms. Becker, do you know whether any other person observed you on March 6th and therefore could vouch for your alibi?
No, I have no idea. I was in a mall, which is generally a pretty busy place, as well as the Fry Shack, so loads of other people could have seen me, as I was going to explain.
And Avery, what did you offer to do to make up for riding on Mr. Brackman's car?
Well, I felt awful about the whole incident, and I offered to do a lot of things. I tried to go to talk to Mr. Brackman in person, and I texted him. I offered to scrub the car, to pay for repainting. I would have done anything. I just feel terrible about the whole situation.
So, did you have any reason for wanting revenge against Mr. Brackman?
Absolutely not. I was upset in the moment about the car thing, but I quickly realized that it was completely on me, and I just wanted to make things right with Mr. Brackman and to smooth things over between us and move on. I had no interest in getting revenge.
Thank you, Your Honor. No further questions.
The witness is excused. Please call your next witness, Ms. Fair.
Yes, Your Honor, the defense calls Taylor Perkins to the stand.
Ms. Perkins, please remember that you are under oath. You may proceed with the witness.
Good afternoon, Ms. Perkins. Please state your name and spell your last for the record.
Hi, I'm Taylor Perkins, Perkins.
Could you introduce yourself to the jury, Ms. Perkins?
Yeah, of course. So I'm a freshman at CU Boulder, SCO Buffs, and I graduated from Colorado High School last year.
Could you describe your relationship with Ms. Becker?
Avery and I were like best friends all throughout high school. We did everything together. We were such good friends. She was able to convince me to join the mock trial team. And I'm like, no offense, I wouldn't necessarily do mock trial if it wasn't for Avery. But I wouldn't have done it. I wouldn't have done it without her. She really made it great.
Could you tell me about your involvement on the team?
Yeah, so my senior year, I was actually on a team with Avery. And honestly, I really just did it to spend time with her. I wasn't 100% committed to the team, if I'm being honest. So when she was demoted to B team, I stepped down.
Why was Ms. Becker demoted to B team?
Oh, it was ridiculous. So it was about like a month, I think, or so before the regional competition. And Avery showed up to practice a bit unprepared. But in classic Avery fashion, she pulled it off. She killed it. She's really a natural when it comes to mock trial. So there wasn't really an issue. But Coach Brackman seemed to be a little bit upset about it. And so that's when he demoted her to B team.
Do you think Miss Becker deserved to be demoted?
Oh, absolutely not. I mean, Avery loved mock trial. She worked really hard for it and was definitely AT material. So that's why I stepped down about a week before regionals to show my support for Avery. If I stepped down, then there wouldn't have been enough people on the team to go to regionals. So Coach Brackman would have had to put Avery back on the team. It ended up working out. Avery got best attorney and best closing argument at the regional competition, which was great. She so deserved those awards, but it didn't seem that Brackman thought so.
What do you mean Mr. Brackman didn't think she deserved the awards?
So there was like a practice after regionals when Coach Brackman gave Avery a bit of a hard time about her performance, saying that she didn't deserve the awards, but she won them fair and square.
How did Miss Becker react to this?
She was upset, rightfully so. She worked really hard for those awards, and that is when she did write Worst Attorney Award on Mr. Brackman's car. And she told me that she believed it to be like an expo marker for the whiteboards, but apparently it did turn out to be a Sharpie marker. But she expressed to me how absolutely horrible she felt about this whole incident.
Did Miss Becker try to fix her mistake?
Yeah, I think she did everything she could to talk to Mr. Brackman, but he didn't really seem to want to hear it. And unfortunately, that is when he kicked her off the team.
How did Miss Becker react to being kicked off the team?
At first, she freaked out. I mean, she loved mock trial. So she texted a lot of people on the team trying to get back on. And I think some people said they talked to Mr. Brackman. And I think she may have texted Alex Cifuentes, but I'm not 100% sure.
Could you describe from your observations Alex and Avery's relationship?
Yeah, so I spent a lot of time with the two of them, like throughout all of our mock trial practices. They were nice to each other. They seemed to get along. They weren't like best friends or anything like that. They didn't seem to be. But I think Avery was one of the best on the team. And I think Alex seemed to have wanted some of the roles that Avery got. So Alex was a little bit overshadowed by Avery.
Were Avery and Alex friends?
Based on all the time I spent with them, they didn't seem to be friends, like at all.
Miss Perkins, could you tell me about the night before Mr. Brackman's murder, March 5th? What did you do that evening?
Yeah, of course. So March 5th, Avery and I hung out that night.
What did you do?
So Avery swung by my house after school, played some games on our phone, you know, us teenagers and our phones. And then we headed over to the Fry Shack to get some food. Not a good idea.
Why not?
So actually most of the mock trial team ended up being there for like a post-practice snack. And when Avery saw them, she seemed to be a little upset and stormed off to the bathroom.
Where was Avery's phone while she was in the bathroom?
It was actually on the table, and I'm not 100% sure anything if she grabbed it again when we left.
Was anyone with you while their phone was at the table?
Yeah, actually, so Alex Cifuentes was with me at the table while Avery was in the bathroom.
What happened the next morning, the day of Mr. Brackman's death?
So Avery and I actually have first period off together. So usually we drive to school together, you know, save some gas money. And I had texted Avery that morning about, you know, like driving together, and she didn't respond to my texts. So when I brought it up with her, that's when we realized that like her phone was missing. So we spent the entire day looking for her phone.
Where did you look?
We went to the mall, retraced all of our steps from the night before. We went to the Fry Shack, and then we went to the Fry Shack again to check with the afternoon shift. And then we, as we always seem to do, we saw the mock trial team there, and that's when we found out that Mr. Brackman wasn't at practice.
Did you try to call or text her phone?
Yeah, so we called and texted Avery's phone a lot throughout the day. You know, phones are expensive, you don't want to replace it, so we really tried to find it. I do have an Android though, so like we didn't think to use Find My iPhone or anything like that, so we resorted to the texts and calls.
Did the police ever try to use your phone to check your call logs for that day?
No, actually, the police never did.
Did the police ever try to use your phone to check your location for that day?
They did not.
And was Miss Becker's phone ever found?
I don't believe so.
Moving on, Miss Perkins, who is Blair Rollins?
Blair was a kid at our school. I didn't really know much about Blair, except we all kind of knew that Mr. Brackman lost a case that sent Blair's dad to jail. I also, I like see kids in the hall, and it seemed that Blair was pretty good friends with Alex Fuentes.
Was Blair at school on the day Mr. Brackman was murdered?
No.
Were you with Avery all day?
Yes, I was. We spent the entire day looking for her phone, retracing her steps.
And did Avery murder Mr. Brackman?
No, I mean, I was with Avery all day. We were nowhere near Mr. Brackman's house.
Thank you. No further questions, Your Honor.
Thank you, counsel. Ms. Dobler, do you have any questions for this witness?
Yes, Your Honor.
Proceed with your cross-examination.
Good evening, Ms. Perkins. Let's start by looking at your relationship with Mackenzie Brackman. Now, you thought Brackman was a mediocre coach. Isn't that true?
Yeah, I mean, he wasn't like anything special.
And you thought he was a mediocre lawyer, yes?
Yeah, I mean, he wasn't a great coach, so I kind of assumed that wouldn't really translate into the legal world.
You thought he made bad decisions for the team, yes?
Yeah, I mean, Avery was incredible at mock trial, and I say maybe it wasn't the best decision demoting her and then kicking her off the team.
And yes, as you mentioned on your direct, the defendant is your best friend, right?
Yeah, Avery and I were like best friends all throughout high school.
And you knew the defendant and Coach Brackman had a feud, isn't that correct?
Yeah, I spent a lot of time with them at practice. They didn't really seem to get along.
Now let's look at your time in mock trial. Prior to the regional tournament, the defendant was demoted to the B team, yes?
Yeah, she showed up a little unprepared and Coach Brackman demoted her.
Yes, Brackman was the one who demoted her, yes?
I mean, he was the coach.
And the defendant was reprimanded again when the defendant wrote worst attorney award on the coach's car, yes?
Well, actually, I wasn't at practice because I stepped down, so I'm not entirely sure like what exactly happened when that did happen.
You're aware that the defendant wrote worst attorney award on the coach's car, yes?
Oh, yeah. No, I know that, but you said reprimanded, so I'm not entirely sure like what exactly happened between Avery and Mr. Brackman.
Ms. Perkins, you know that the defendant was kicked off the team, yes?
Yeah, no, I know that.
And Coach Brackman was the one who kicked the defendant off the team, yes?
I mean, he was the coach.
And now you looked for ways to help the defendant get back on the team, yes?
Yeah, we kind of strategized. I mean, she loved mock trial, so we wanted to help her get back on the team.
But Coach Brackman didn't let her back on the team, did he?
He didn't really seem to want to hear her like apologies or anything like that. But she tried really hard to apologize.
Brackman did not let the defendant back on the team.
No, he didn't.
Now let's look at your relationship with the defendant. You quit in solidarity with the defendant after she was demoted, yes?
Mock trial wasn't really my thing. I didn't love it, so it wasn't a big deal. And I was happy to do it if it meant success for the team and Avery could get back on the team.
That's a yes. You did drop. You did drop to the B team for the defendant.
Yeah, but it was no big deal.
And now on March 6th, no one at the Fry Shack can confirm your whereabouts for the entirety of the day on March 6th. Isn't that true?
Objection, Your Honor. Lack of personal knowledge.
Do you have a response, Ms. Dobler?
Yes, Your Honor. In the witness's affidavit, she has mentioned that she was with Taylor Perkins only for the entirety of the day. Therefore, she should be able to answer this question.
Counsel, do you have a reply?
Yes, Your Honor. I believe opposing counsel was asking if she knew anyone else to have recognized her, and that is outside of the scope of this witness's knowledge, as she would not know.
I agree the objection is sustained. Ask your
Thank you,
next question.
No, Ms. Perkins, no one who worked at the mall can vouch for your whereabouts for the entirety of the day on March 6th. Isn't that true?
Objection, Your Honor. Same objection, lack of personal knowledge.
The objection is sustained.
Ms. Perkins, no one was with you and the defendant for the entirety of the day on March 6th. Isn't that true?
It was just Avery and I. We were looking for her phone.
Thank you. No further questions.
Any redirect of this witness?
Yes, Your Honor.
Proceed.
Ms. Perkins, could you describe your relationship with Avery Becker?
Yeah, we were best friends during high school. Avery got me to join the mock trial team, and then I did end up stepping down from the A team to benefit the team and also so Avery could get back on the A team.
Why did you quit the team?
It really was like just to benefit the team. I mean, like, I didn't love mock trial. I just did it to hang out with Avery. But I knew Avery loved mock trial, so I was happy to do that for her.
And do you know if anybody recognized you at the mall that day or at the fry shack?
No, I mean, it's a mall on a Friday afternoon. Probably there's a lot of people there. But to my knowledge, no one else has like recognized me or anything like that in this case.
No further questions, Your Honor.
Thank you, counsel. The witness is excused. Thank you. Are the parties ready for closing arguments at this time?
Yes, Your Honor, the prosecution is ready.
Yes, Your Honor.
You may proceed.
May it please the court, Your Honor, members of the jury. My name is Anjali Mishra, and today my co-counsel, Anna Debler, Kaylee Langan, and I represent the people of the state of Colorado. And we have brought forth the charge of murder in the first degree and burglary in the second degree against the defendant, Avery Becker. The case today is a simple story of revenge gone wrong. Now, during this trial, you first heard from the prosecution's witnesses. You heard from Detective Jordan Markowitz, who is experienced in cell phone forensics. She told you how the cell phone records from Exhibit 15 indicate that Miss Becker was at the scene of the crime at the time of the murder. You then heard from Alex Cifuentes, a student on the CHS mock trial team. She told you how truly contentious the relationship was between Coach Brackman and Miss Becker. You finally heard from Kyle Cusack, a very experienced crime scene reconstruction investigator who broke down her thorough methods. She told you how the horizontal knife wound only makes sense with her theory of the case. She told you how all of the evidence indicates that Miss Becker is the perpetrator in today's crime. Now, you next heard from the defense's witnesses, and at the beginning of this trial, my co-counsel, Anna Debler, warned you to be wary when approaching their testimony, for it is filled with bias. You first heard from Blake Van Owen, who left a job in public service working for the Aurora PD in order to become a highly paid private investigator. Her theory of the knife being held vertically makes no sense with the clear horizontal knife wound. She baselessly tried to attack the prosecution's case, but her accusations are not substantial enough to provide reasonable doubt. You next heard from Miss Becker herself, who told you how tense her relationship was with Mr. Brackman, how she in vengeance insulted Mr. Brackman by calling him the worst attorney in the state, how she in vengeance vandalized his car, damaging thousands of dollars worth of property, and how she in vengeance vowed to get back at Mr. Brackman if it was the last thing she did. You finally heard from Taylor Perkins, the best friend of Avery Becker. She is also the defendant's sole alibi for today's case. She disliked mock trial and manipulated Coach Brackman to force him to put Miss Becker back on the mock trial team. Due to this relationship, members of the jury, Ms. Perkins is clearly biased, and I ask that you disregard all of her testimony here today in court. The murder of Mr. Brackman is the simple story of revenge gone wrong. Our duty today is to prove that the defendant is guilty, and members of the jury, we have met our burden and proven this to you beyond a reasonable doubt. I ask that you find in favor of the prosecution and find the defendant, Avery Becker, guilty on all charges. Thank you.
Thank you, Ms. Misra. Ms. Hayden, do you have a closing?
Yes, Your Honor.
You may proceed.
Thank you. Your Honor, members of the jury opposing counsel. In this case, there was no phone, no files, and no felony. Might I remind you that the prosecution holds the entirety of the burden of proof in this case. That means that they need to prove every element of this crime beyond a reasonable doubt. Not only have they failed to prove every element of this crime, they have failed to prove any single one. The prosecution's case was saturated with incompetence, both in the evidence that they did collect and in the mounting evidence that they did not even consider. No phone, or should I say phones. Both Detective Markowitz and Mrs. Kuzak would lead you to believe that they are sure of the whereabouts of my client on March 6th. They want you to think that the cell tower data that they found tells us everything that we need to know. This simply isn't true. Cell towers aren't tracking devices. Phones don't always connect to the nearest one. Besides, regardless of the location of Miss Becker's phone on the 6th, it was not in her possession. On the other hand, there were 2 phones that Detective Markowitz and Mrs. Kuzak did know the location of. Taylor Perkins and Alex Cifuentes' phones were not investigated in this case in the slightest. Mrs. Markowitz chose to hinge her entire case on screenshots sent to her by a teenager that she chose not to authenticate. Why? Because she was simply too lazy. This laziness is also apparent in the fact that she did not ask for Taylor Perkins' phone, which could have confirmed or denied Avery's alibi on March 6th. Next, no files. And yet another example of the police department's amateur work, photos of the crime scene were corrupted and lost. Ladies and gentlemen of the jury, how can we say that this case is open and shut when its experts cannot even keep track of their evidence? Finally, the felony. Today, Avery Becker is being falsely charged with 2 counts: murder in the first degree and burglary in the second. Members of the jury, the prosecution has deemed this case a revenge gone wrong. What revenge? Avery had no reason to get revenge on her coach. Avery didn't know where Brackman lived, and besides, Avery's not tall enough to stab Mr. Brackman standing up. The prosecution has left us with questions, not answers. Here's some things we know for sure. We know that the prosecution failed to look into any other suspects, including Blair Rollins, whose father, Mackenzie Brackman, sent to prison. Rollins was not at school on March 6th and seems to have disappeared since then. This, of course, did not stop Detective Markowitz from reminding us that Blair Rollins' home is within the exact same cell tower range as Avery Becker's. You want to talk about revenge? Let's discuss Blair Rollins. We heard the prosecution's only character witness say that she wanted her time in the sun. She was jealous of Avery and had a reason to keep her off of the team. Ms. Cifuentes was the one who pointed Detective Markowitz to Avery Becker, and members of the jury, might I remind you, she was the last to see Becker's phone on the 5th. We know that there is not a shred of physical evidence in this case. The only things tying Avery to Mr. Brackman are assumptions and coincidences. We know that the prosecution took the easy way out. They made assumptions across the board and failed as investigators. They spun a story not based on facts, but on the first witness that they could find. Finally, we know that there is more than a reasonable doubt in this case. There's a sizable one. The evidence presented by the prosecution is fundamentally lacking in every way. Today, my co-counsel and I have shown that there was no phone, no files, and no felony. Since the prosecution has absolutely failed to meet their burden of proof, which is beyond a reasonable doubt that Avery Becker committed murder in the first degree and second degree burglary, you must find her not guilty. Thank you.
Thank you, counsel. We are going to allow a few minutes for the panelists to tally their scores and submit them.
Your Honor,
Yes.
may I be allowed to present my rebuttal for the closing?
That's right. You did reserve rebuttal. I apologize, Ms. Misra. You may proceed.
Yes, Your Honor. No phones, no file, no felony. This is the claim that the defense has provided for today's case, but let's break that down a little bit. No phone. Today, Detective Markowitz clearly testified that she had no need for the phone. She is experienced in cell phone forensics, and she told you she had no reason to believe that the screenshots had been tampered with. Number 2, no files. Once again, Ms. Kyle Cusack testified before you today in court that the lost images had no actual result on her findings. She had a mountain of evidence from which she created her conclusion. Number 3, no felony. Miss Becker in this case is clearly guilty. She has been charged with this felony for a reason. Now, members of the jury, I will propose another rule of threes for you to examine. No alibi, no acceptable explanation, no acquittal. First, no alibi. Ms. Perkins was not able to provide a solid alibi for Ms. Becker on the day of the murder. Number two, no acceptable explanation. Ms. Van Owen was not able to provide an explanation for why the knife wound was horizontal and not vertical like she claimed. Three, no acquittal. Ms. Becker does not deserve to be acquitted in this trial today. This story is simply about revenge gone wrong. We have proven this to you, members of the jury. We, as the prosecution, have the burden of proof to prove to you beyond a reasonable doubt that Ms. Becker had the intent to enter Mr. Brackman's home illegally, and we have proven that to you, members of the jury. We ask that you find in favor of the prosecution and find the defendant guilty on all charges. Thank you.
Thank you, counsel. Now the panelists should go ahead and tally their scores. I apologize to Ms. Mesra for interrupting. And panelists, I would like you to go ahead and turn on your videos when you are ready and have submitted your scores.
Have you all submitted your scores sheets?
Yes.
Thank you.
Thank you. So team members, please go ahead and all of you turn on your videos, including the scorekeeper, or not the scorekeepers, but the timers. Thank you. So congratulations on getting another round under your belt. Very well done. I'd like to congratulate all of you. This is an interesting virtual world that we live in, and you've clearly risen to the occasion in being able to present the way you have. So I'd like to congratulate you in doing that. My name is Elsa Martinez Tenredo. I'm a judge with the Division of Workers' Compensation. I have been involved in the mock trial program in one way or the other for a very long time, since way before you were born. I think I started with nationals in '95, so that's a long time. I have done everything from obviously presiding to being a panelist to recruiting panelists, coaching, giving lectures about the program, everything from scorekeeping or tallying scores to writing the case material and witness statements. So I've done just about everything involved in this mock trial program, and I think it's one of the best programs offered for young students like yourselves. It's an invaluable program that allows you to develop skills that you may not otherwise have developed. So I'd like to congratulate all of you for a job very, very well done. But most of all, I'd like to say thank you to the Colorado Bar Association for putting on this kind of programming. I'd like to thank your teachers, your coaches, your family members with whom you would not be able to accomplish what you have accomplished. So I hope you go home and thank them as well, because this is a great learning experience that is not offered to everybody and that everybody does not have access to. You've put in a huge amount of effort and work into this program, and clearly have accomplished much because you're here at State. So congratulations. So with that, I'd like to go ahead and let's pick on one of the panelists to give comments. David, would you like to start the process?
Sure. First of all, my qualifications, as it were, is I'm a legal IT specialist for 2 law firms here in Colorado. So we are all experiencing these virtual trials. So the way that you're all adapting to this is commendable. I appreciate you, and I appreciate your technicians who are bringing everything up on the screen for you. They're kind of the unsung heroes, as it were. So good job for adapting and overcoming. So good job on that. So I am also a IT specialist for NITA, which is National Institute of Trial Advocacy, where they train real attorneys in the skills that you guys are excelling at. It's amazing. One of the things that they really pound on you in NITA is your opening and your theme. And they really pushed the rule of the 3. Revenge Gone Wrong was a very good theme, but I don't know if that's actually a rule of 3. You did use 3 words, but I felt that No Phone Files Felony was a stronger theme and a use of the rule of 3. But I was kind of stuck on felony, no felony. Well, there actually was a felony committed, but you were trying to prove whether or not it was her. So I enjoyed the themes. I just think they could have just used a touch more work on that. I think Kylie, K-A-Y-L-I, used a very powerful tool. I love watching it in court. It's read along with me. That leaves no room for error. You know, some attorneys have the person on the stand read it, but you know, then they get to put in their own feelings and their own emotions. Where you, the attorney, reads it, it's a very powerful tool. You know the old saying, if you want something done right, do it yourself. So I was really happy to see you use that. Lola, I loved you on cross. You had a very good line of questions. Not only could I follow your questions as a jury member, I could also see where you were going with it. So I thought your cross was very, very powerful. So I thought that was great. I'm just jotting down a quick couple notes here. I'm sorry, I'm not going to be able to hit everyone. Anna, I thought you did very well with and against objections. Objections are you're probably your most powerful tool because it's how you control the game. Anjali, I loved your rebuttal at the end. You turned their theme against them. I thought you did excellent on that. I want to also quickly point out okay, I know you're in high school and you're teenagers, but some of you like Saffron and Maggie, you actually exuded the teenager roles that you were playing. So I thought that was Maggie, you really had attitude. You know, I thought, okay, she's definitely playing a good teenager. But Lily, as your expert, you used analogies as I, the jury member, was able to understand and follow. Really, really good. I like that, but I think you might have used one too many. You know, it was a really good role for you to do that, and I think you did it great. Just go a little bit lighter on that, but that's what I have.
Thank you, David. Jason, do you want to pick up the comments next?
Sure. You know, I agree with everything that was just said. I think you guys have done a remarkable job. It was phenomenal. I will admit that my 11-year-old daughter came in and peeked at the screen and was elated to see so many young attorneys that she can look up to. Anyways, I think, again, just to reiterate, you guys did phenomenal on your themes. I really appreciated those. They were clear. They throughout the entire process. A lot of times you'll hear it at the opening and then it kind of just disappears. And then you hear it at the closing again. But I think you both did a really good job of keeping those consistent throughout, which helps the jury follow that. I guess, sorry, I forgot to introduce who I am a little bit. I'm a town attorney now, municipal government attorney. I work as the in-house counsel to the government. I've been doing that for 9 years or so. I prosecuted for about 7 years, and I've been involved with the mock trial since my time at DU Law School. I coached mock trial while I was there and have been judging competitions for the state bar association and also the Providence Cup for 10 years now or so. And I think you guys have done a remarkable job. Both teams, better teams than I've some of the best teams I've seen in the last 10 years. Sorry, 2 rounds in a row. I'm getting tired as well. Just a couple of notes for you. One of the things I think it's really, really hard to remember is that when you're on a redirect, you have to ask direct examination questions, not leading questions, because that's always hard. You hear cross-examination for the last 10 or 15 minutes, and you get into that mindset when the witness gets back on the stand to say, isn't it true this, isn't it true that? Or so try to step back and remember that. But you guys did phenomenal. And typically in these notes, I don't get into the facts of the case because you guys know them far better than I do. But one of the things that struck me today that I thought was interesting is if the victim had pulled the knife from out of his back and there's blood all over this knife, why isn't there any blood all over the guy's hands? I thought that was weird. The pictures doesn't show anything like that. But again, I don't know what the facts are stipulated, so I don't want to get too far into the weeds. But again, I wanted to say congratulations. You guys both teams did phenomenal. Thank you for letting me participate.
Thank you, Jason. Greg?
Hi. Just want to congratulate you all on a great job. Obviously, since we're at the state, it means you all did really well in regionals, and I can certainly see why. I'm Greg Rich. I'm a civil litigator. I handle mostly the defense of civil cases, a lot of construction law, some personal injury, things of that nature. My history with moot court mock trial, I was on moot court for a couple years at DU. I did both the trial and appellate teams. I coached a little bit after I got out of law school, judged some, took some time off, and have been enjoying judging this year. This is my 6th round of this problem. 4 rounds at regionals and now 2 rounds this weekend. I've also taken the NEDA courses that David was talking about. And those are valuable courses. I've also done NEDA-like courses, basically trial academies for young lawyers. And the skills that you guys exhibited today are on par with what I see from 2, 3, 4 year lawyers who have come out of law school. And it's a very similar situation. So you guys are certainly put in the time and you're quite advanced. Let's kind of go through, unlike Jason, I will disagree with David on a couple points. I'm going to jump around a little bit. On reading from the document, I like that on cross-examination. I'm not as big a fan on it on direct. On direct examination, the lawyer wants to shrink back and let the witness be the star. And so, especially when it's their own words. So when it's their own words, let the witness say them. Don't read them to the witness. I will say that that you did a good job on, let's see. Okay, on that same direct, I wasn't buying the it's very polite because I really liked, is it, how do you say your last name, Lola? Is it?
Fakes.
Fakes, okay. I really liked that line of questioning that you gave on the cross-examination. It was, you were incredulous of that situation. And like David, I saw where you were going and I was anticipating it as you were doing it. And this is the 6th round I've judged and I hadn't seen that done before. I hadn't seen that line of questioning. So I commend you, that was really good. You have a little bit of a tick on cross-examination, many lawyers do. When you get an answer that you're not buying it, you say, okay, and then you move on. And it's something that I picked up on. And whenever you didn't believe something, you said, okay, and you moved on. And it was great because anytime you said, okay, I'm starting to think, do I believe what was just said? Let's see, Miss Moskowitz as Detective Markowitz. I guess you were born to play that role. It was, I really enjoyed your performance there. One of the things I have an issue, and I'm going to be mostly critical because you're all really good, and I think my job is to help you get better and learn. So please don't take these comments as me thinking that you're not good. I'm just trying to get you to that next level. I concluded that she's guilty on all counts. That's not an expert's job to conclude someone's guilty on all counts. That's the jury's job. You can conclude that she did the thing, but you can't conclude that she's guilty on all counts. And so I would be careful of that type of statement. Also, I wasn't agreeing that the hand position looked defensive. It looked like somebody fell. It doesn't look, I mean, yeah, the hands are here. If they were standing up, that's defensive. But when they're on the ground, that's just where they fell. They're trying to catch themselves. So I wasn't really agreeing that it looked like a defensive hand position. So that to me made it a little bit less credible. Let's see, Ms. Dobler, I think you did a great job on the direct though. I think all the directs were strong in that you were asking the W questions: who, what, where, when, why, or why is usually not as good one, but how. Also did is a good direct question because it's not leading, but it allows you to lead the witness to a place. Did this happen? It's not leading because it doesn't suggest you have to answer yes or no. But it can be effective if you need to kind of lead your witness to a place saying, did something happen? That's a good one as well. Ms. Hayden, on your cross-examination there, I saw Ms. Murphy and Ms. Hayden both did this. Ms. Hayden said, no voir dire, I'll address the shortcomings on cross. And Ms. Murphy said, my questions regarding credibility will be addressed on cross. That was nice. You didn't waste time on voir dire, but you already said, okay, there's going to be issues here. So that was a nice little tactic. Ms. Murphy, I really like the way you ended your cross-examination. That last series of questions was really good. It was really strong. Let's see, Ms. Fakes, on your cross-examination, so that's a no, so that's a yes. Really getting that answer, that was well done. You didn't end with as big a punch as I would have hoped. Maybe you could, make sure that your ending of a cross-examination is really, a big issue. Yeah, and Ms. Hayden, you also, you showed confidence in your, I have no problem with 15, that's fine. right? It's just, yeah, I'm good. Showing confidence is good. Let's see. Ms. Rowe, I think you had a really good tone and demeanor on your direct examination. I really enjoyed that. You had, the way you admitted the evidence was, really nice and smooth. That showed a lot of good competence there. That was nice. One issue I had with Cusack is that the most important issues were the scuff marks, the plate, and the knife. None of those, to me, listening to this, implicate the defendant. It implicates something, but it doesn't necessarily implicate the defendant. So just think about that. I did really like the horizontal, the way you explained that. This is Hylden. I think that was really good job of how you explained the angle of the knife. That was well done. Let's see. Okay. Let's see. I think it was really good. Miss Humber and Miss Murphy on Vano and the direct. It was a really good back and forth. Right. It was overlooked and Bosch. Okay, what was overlooked? All right, let's talk about each of those things. I think the way you guys went back and forth was fantastic. Let's see. I think it was maybe a little bit overdone at the end of that one, though, where you said, let me say that again. No, and all you did was said the theme. And so what that made me think is that when you're working with your expert, one of the things that you're doing with an expert is trying to develop a theme. So it makes me think that the theme was the expert's theme and you guys just went with it. Not necessarily a bad thing. It's just, it made me think that this is where the theme came from, the expert. That's assuming it's a real trial. Let's see. I liked Ms. Nusra on the cross there, bringing up the defective Markowitz. I just thought it was a very effective cross-examination of Vano. And Miss Bennett Spurlock, I thought you were a fantastic Becker. You did a really good job with that. Made the worst mistake of my life. I think that was really good because it seemed natural. And if you believe that you had actually committed a crime, that wouldn't clearly have been the worst mistake of your life to ride on a car. And so I thought that was a nice point. Ms. Hayden, you did great looping, good responses to objections there. Ms. Langen, I thought you were a little mechanical, but then you had your list of questions that you were going to ask, and you had the order in which you were going to ask them. At trial, you need to try to be a little bit more flexible. They were good questions, but you knew what you wanted to ask, and it's almost like you were just checking off the box. I see it in deposition all the time when lawyers don't know a case and they're asking questions and they're just checking off a box with the questions. So you were listening to the answer, but you said, we'll get back to that. We'll get back to that. Sometimes you just got to rework your outline, and okay, let's talk about that now then. But I did like how you, I thought the second half of your cross-examination was much better, and how you needed to control the witness, because this is a witness that wasn't going to be controlled. And you did a really good job of controlling the witness. I think that Ms. Hayden, at the end, right, when she cut off the witness on that last question on the cross-examination, you ended up letting her say the answer, but how about before you were interrupted, what were you going to say? Because then it makes her look like a jerk, which is what you want to do. I thought that Miss May did a great job as Perkins. That was a really good performance. I enjoyed that. You were a good friend. Let's see. One question that I wasn't sure, Ms. Fakes, was Blair at school the day Beckman was murdered? How would she know? She wasn't at school. And then when Perkins says, yeah, we strategized about, how to get Avery back on mock trial, Ms. Dobler, use that. You strategized, did you? You know, what else did you strategize about, or come up with something like that? Ms. Misra, that might have been something good to bring up on the closing as well, right? So that's something to consider. On the closings, I like your rebuttal, Ms. Misra, more than your the main closing. You saved a lot of time, which was nice, and you really nailed it on the rebuttal. I wouldn't have started the closing by reintroducing yourself. Been through a whole trial, we know who you are. Start with your theme, and Ms. Hayden, you did a fantastic job of that. You started with your theme and you just used it throughout. And what I liked about your rebuttal, Ms. Misra, is that you came back with their theme and you used their theme against them, which is a very strong thing, and you did that very effectively. So with that, I will just say one more time, I really enjoyed watching the performances throughout, and I wish you guys luck in the additional rounds.
I also want to congratulate you. I'm not going to keep you any longer with comments that have already been said. One of the things that I just can't emphasize enough, it's very important to keep eye contact. And in this virtual world, it's really hard to do because you're looking at a point on a camera. But it's actually very effective. Some of you did a very good job at keeping that eye contact with your audience. Some of you were looking down towards the bottom of your screen. So that's one of those things that I guess is just a technicality, but it is very effective to have that kind of eye contact, that kind of connection with your audience. So again, congratulations to both of these teams. You did a fabulous job. I really enjoyed listening to your arguments and congratulate you. I wish you the best of luck for the rest of the competition. Thank you so much.
Thank you all.
Thank you.
Thank you.